Staff to hand out. Thank you. We're on TV.
Thank you.
Good afternoon. Welcome to the Planning Commission meeting, a regular meeting of the Planning Commission for Wednesday, July 18th, 2012. I would like to have a roll call.
Planning Commissioners Astorian.
Here.
Lee. Here. Sheets.
Here.
Yesayan.
Here.
Chairperson Landrigan.
Here. Can you please give me a report on the posting of the agenda?
Yes, the agenda for this meeting was posted on Wednesday, July 12th, 2012, on the bulletin board outside City Hall and on the city's website.
Thank you. We will do the Pledge of Allegiance. Mr. Storm, will you lead us?
I'll be happy.
Thank you, sir.
Please follow me in our Pledge of Allegiance to our flag. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. It's the wrong teacher habit. I want to make sure.
We noticed. Thank you.
It's a creature of habit.
We have before us the minutes of the meeting of June 20th, 2012, one of our regular meetings. Do we have a motion to approve or any changes?
I move that we approve the minutes of Wednesday, June 20th, 2012.
All in second? All in favor?
Aye.
Any abstentions?
Abstain.
2 abstentions. We have now come to oral communication. I don't have any cards for oral communication. So seeing none, we will go on to zoning appeals. And we have before us a conditional use permit case number PCUP 2011-031 and administrative exception case number PAE 2011-23. And we will have staff give us a brief overview of the application and decision. And this public meeting is open.
Correct. Chairperson Landrigan, Planning Commissioners, the first case on tonight's agenda is an appeal of a conditional use permit for the sale, service, and consumption of alcoholic beverages at a restaurant, and also an appeal of a denial of an administrative exception to add 438 square feet to the restaurant without providing 3 additional parking spaces. The applicant is Mr. Fred Teichert, and the property is located at 2833 to 2839 Honolulu Avenue. The project site is zoned C1 commercial neighborhood, and the land use is a neighborhood commercial zone. The site currently encompasses a multi-tenant commercial building of approximately 8,300 square feet. It has a barber shop, an office use, and the current restaurant. The site also features 26 on-site parking spaces. The original restaurant on site was built in 1953, and it received its first conditional use permit for alcoholic beverage sales in 1966. It had operated as a restaurant with alcoholic beverages being sold and consumed on site since 1966 up until 2010, when at that point in time the City Council and the zoning administrator went through a revocation process. The previous tenant was Montrose Collection, which was approved as a restaurant with alcoholic beverage sales. Unfortunately, they violated a number of conditions of their conditional use permit and of the zoning use certificate. At that point in time, they were also allowed, and this is back in 2005, they were allowed to expand into the adjacent office tenant space without providing 9 additional parking spaces. So because of the violations that they were operating an unpermitted banquet hall use, The parking reduction permit was actually revoked by the City Council in 2009, and then following that, the zoning administrator actually revoked their zoning use certificate. So at that point in time, all permits were essentially revoked, and the restaurant essentially stopped all operations in 2010. They had refiled a parking permit reduction permit, that is, and a conditional use permit to reopen the restaurant with the additional space, but both of those applications were also denied in 2010, so they have been closed since that time. The current owner of the property is now going forward with a conditional use permit and with an administrative exception, and they have a new business operator. So this would, the previous business operator of Montero's Collection has left completely, no longer in operation. This would essentially be a brand new restaurant that is coming in and proposing to sell alcoholic beverages as part of their meal service. They are at this point in time requesting to add, or in this case continue legalizing or using 438 square feet for their restrooms, and these would be handicap accessible restrooms. The previous restrooms that were inside the restaurant were of inadequate size. They weren't handicap accessible, and so they'd like to continue operating what was previously legally expanded and then revoked. They would keep only 438 square feet. This would be just for the restrooms only, and they would convert that additional space that was previously converted back to an office use. Because of the conversion of the bathroom space from an office to a bathroom, there is a difference of 3 required parking spaces, because essentially a restaurant use has a parking demand of 10 parking spaces for every 1,000 square feet, and that would be gross floor area. An office has a parking ratio requirement in the zoning code of 2.7 spaces per 1,000. So when you calculate out in the grandfathered spaces, essentially this 438 square foot expansion for the bathrooms would essentially require 3 additional parking spaces. Through the administrative exception process, they are allowed to go ahead and request an administrative exception, provided that it is somewhat of a small request that is consistent with the AE, or the administrative exception parts of code. So essentially there are 2 processes going on simultaneously. The CUP was denied for alcoholic beverage sales, and then the administrative exception was denied for allowing the expansion of the restaurant without providing the spaces. The planning hearing officer, in reviewing the CUP at a public hearing, and then taking into account the administrative exception concurrently, that is, but not at a public hearing, essentially made the determination that the existing site with its 26 spaces on site is already considered legal non-conforming. It would be considered substandard if this was a new construction. However, again, this, as I relayed just briefly the history, this particular commercial complex has been in operation essentially in the same type of configuration since 1966. But yes, it is legal non-conforming in terms of the number of spaces. By allowing, or in this case, approving an administrative exception to then further not require 3 additional parking spaces, it would essentially be then further impacting this deficit in parking. The property owner, and I'd like to come up to the board if you don't mind to describe actually the parking situation. You'll notice here, this is the commercial shopping center. You have 26 spaces on site. There is an alleyway to the north that you do have multifamily and single-family residential to the north, but you have C1 all along Honolulu, and all of these essentially have commercial shopping center one after another to the east and west, and there is a senior living facility to the south. To the west, there is a shopping center that both of these adjacent tenant spaces essentially utilize an existing driveway, and then you have parking spaces that are perpendicular to the buildings, that are parallel to the street, that also use this type of going over the property line, that you essentially need all of this space as the required backup space for the two adjacent buildings, the parking spaces that face each other. The this project site's property owner entered into a temporary access easement with the adjacent property owners to utilize this common driveway and to utilize this area to the north of the common driveway as the required backup space for the two properties. So it would be a reciprocal access easement. As part of providing the required parking, in this case, allowing for all of the required backup spaces for the parking spaces on site. This parking, this temporary access easement was recorded. However, the planning hearing officer felt that because of the parking situation on site and the fact that the recorded easement is not binding, there was no time limit on the access easement, and there was also the possibility that this access easement could be revoked at any time between the two property owners if there was ever a possibility of redeveloping the property. So essentially, if the property owner next door came in and decided, for instance, in 2013 that he wanted to go ahead and sell the property, then essentially that easement will be, with no proper notification, the easement will become null and void. So there is no binding time limit, no binding set of circumstances that would require that easement to be in effect. With that said, these 11 spaces that are essentially accessed through this common driveway and utilize this access easement for its required backup spaces essentially would become non-compliant with code. And so that would even further reduce the parking situation and impact the parking situation on site.
In case of development.
In case of development, correct.
So, is the other going to be using it more? If
Well,
this goes forward?
correct. Both adjacent property owners would be under the same set of circumstances. Now, I just briefly summarized. Essentially, those were the grounds for her denial of the AE and of the conditional use permit. The applicant, the property owner, went ahead and filed an appeal of the denials, stating that there should have been a condition of approval or whatnot. They've actually subsequently come forth with an agreement with the adjacent property owner. And both property owners are willing to enter into a binding 5-year easement for the access and the backup turnaround. So this particular easement, it has not been recorded because, again, they went to the trouble of recording the last one. They want to make sure that there's some sort of determination from the Planning Commission that if they go ahead forward, this would be a binding 5-year easement. It would not be able to be changed. If there's a change in ownership, this easement would have to be reviewed and approved to form by our city attorney. It would not be revocable without the city's consent. And so they are essentially going forward saying we are addressing the greatest concern, that the planning hearing officer had in terms of the revocability, the non-binding aspects of the previous easement. I see Mr. Osayan has a question. So
that happened.
Correct. Now, this is part of the appeal. As part of the appeal,
You don't have your,
as part of the appeal,
Yeah.
the appeal filing, the applicant has gone forward, says that we'd like the Planning Commission to consider instead a binding 5-year agreement access easement. The adjacent property owner has also included, and I should say I included a letter from the adjacent property owner saying that he is agreeing to go into a 5-year term limit for this access easement. And he understands that this would be reviewed by the city attorney, approved to perform, and then go forward with that. So essentially, we have both property owners agreeing to, for at least this 5-year period, to not change the parking conditions, to leave it as they are, as they have been for the last 45 plus years.
So after 5 years, would it come back to us again?
With a time frame, if the Planning Commission chooses to overturn the denials and approve the CUP and the AE, there would be a request made to have the CUP be good for a 5-year period. At that point in time, and as part of the conditions of approval that were included in your staff report, the CUP would have to be applied for all over again. And at that point in time, they would also, again, have to show that they can either meet parking off-site or provide another, time frame or permanent easement, which in this case, most likely, the property owners are not willing to enter into because a permanent easement would encumber essentially both properties and not allow for any future redevelopment. But at least this would be an incrementally phased approval for the CUP and the AE.
Are there other questions for staff?
I have one. The driveway,
Yes.
if the property sells, developed independently, where does the driveway stand as far as ingress and egress to either property?
If the easement is rescinded and one property sells, whichever property does not sell essentially has to modify their property
Correct.
to meet code. In this case, if the adjacent property was to sell, the subject property would then have to modify the existing driveway and the existing parking spaces to meet code as much as possible, and then have to provide parking off-site with reciprocal easement. It can go through a parking use permit. It's a parking is adjacent or within proximity close to it. So, and I believe Mr. Tim Foy would like to interject.
Yeah, if it's during the course of the 5 years for which, they have an easement, then the property owner who is not selling still has the right to exercise, to use that easement for the stated purposes.
Correct.
For the time frame.
For the time frame, correct. For the 5-year would be binding.
Right,
This
so
would not happen for the 5-year period.
Right. But beyond that would go into the situation she just explained, that they'd have to provide an entrance.
Yeah, at the end of the 5 years, either the easement is, re-upped, or or a parking reduction permit is obtained, or there's off-site parking obtained, or use of the building changes.
Okay, thanks.
Or nothing is obtained and the restaurant cannot be operational because of the 3 parking deficit.
Or it needs to.
Actually, this is just a condition of the CUP for alcohol.
I do have a question. What was the use prior to Montrose Collection for this space?
Prior to Montrose Collection, there was a brick, it was called BRIC. It was a brick restaurant, the brick
It
restaurant.
was Italian.
And it was, yes, it was an Italian
good.
restaurant. So, and at that point in time, and this was not, again, not with the expansion, it was the original area
Square footage.
prior to the 2005 expansion. It appeared that it was a restaurant, it had alcohol, it had wine or alcoholic beverage service with its meals, and at that point in time, there appeared to be no negative impacts due to the parking situation.
And how long was that restaurant there?
Again, the restaurant was constructed in 1953. I'm not sure if that particular, the brick restaurant, how long that was there. I could double check and look through the zoning use certificates, but there's been a restaurant in that location with a conditional use permit since 1966.
And if I may interject again, I'm sorry. Brick Montrose, I think it was the name of it, they also held banquets. So in the year 2002, when the city adopted an ordinance that for the first time distinguished restaurants from banquet halls, they had a grandfathered right to continue closing to the public and holding banquets, which is how Montrose Collection had a right to hold banquets, except they eventually violated their conditions of approval.
Correct.
Was, since you brought that up, Mr. Foy, the restaurant, and I, there is a sanity to my line of questioning, and I'll get there in a moment, but enlighten me, if you will. When this restaurant was also allowed to hold banquets, it was like an incidental use, not a whole, or was it, Do you remember that?
It may have been their practice to be incidental, but the city regulations did not limit them that way.
See, and again, this was back in 2005 when Montrose Collection expanded into the adjacent tenant space and did not, and their parking reduction was approved, not providing 9 additional parking spaces for the expansion of the restaurant. You could clearly see there was when you compare the 2 floor plans of the Montrose Collection and this currently proposed restaurant, the nature of the restaurant use was rather different. And it was in violation of their parking reduction permit conditions of approval that it escalated to the point where City Council had to revoke the parking reduction permit, and then later on, the zoning administrator revoked the zoning use certificate.
One more question. If we talked about this easement that will be recorded sometime in future that is going to have a termination 5 years, how long is the lease? This new lease with this new restaurant?
That I would have to defer to the property owner. Again, the restaurant, or in this case, the conditional use permit would be contingent upon the validity of a 5-year easement. The restaurant would have to operate per the existing outline. I believe that in your packets, you can see the existing floor plan. It would have to be in conformance with the approved floor plan. They would not be permitted to operate as a banquet hall. It would only be a restaurant. They would be allowed to go ahead and have up to 30% of their restaurant floor area be used for private parties. But again, this would only be up to 30%. This would be in compliance with the standards in the zoning code.
Would, though, if the lease is less than the 5 years, another restaurant be able to assume both the CUP and the AE?
Correct, but that new restaurant would have to operate under the same type of guidelines and constraints. So they would have to be in compliance with the approved floor plan and any type of conditions that the Planning Commission decides to place on this if they choose to proceed with an approved CUP.
And the easement is with the landlord or with the restaurant?
The easement is on the 2 properties,
So it is with the property owner?
with the properties only. Correct.
Maybe I should wait to ask this question. This 3 parking deficiency that we're talking about. From what I'm hearing, these are all located in that easement, right?
No.
No.
It could be anything.
The 3, essentially by expanding the restaurant and providing the 438 square feet for the handicap bathrooms, the restaurant would be required to provide 3 additional parking spaces.
And where are they going to come up with
That's
that?
it. They are requesting an administrative exception because they have no room to provide the 3 additional spaces on site.
So the easement is just for the ingress, egress, and backing
Correct.
out and so
Right.
forth
Correct.
to make it easier.
The easement is purely for a
Valid.
common driveway and the required backup space. So it'd be a common access easement on the properties themselves, not with the uses.
Mr. Sheets?
I have a question. Let me see if I can formulate it. If we go back in time, there was another restaurant. There was a Mexican restaurant, distant past. I don't know if there are any issues about parking with them. I don't know if you're aware of that. But my point is, then at some point it became this restaurant, the Brick Restaurant, which we don't think had parking issues, but it was allowed to to perform banquets.
According to records, it was allowed as a legal nonconforming grandfathered
And there were no
Restaurant.
parking issues that you're aware of.
that I'm aware of, no. But again,
But we didn't check police records or anything on
Correct.
this.
We did not
So
go that
That would be
far.
a difficult thing to...
So the parking issue then came up with the previous use when they expanded site
correct.
incorrectly. And so then, at that point, a number of other things occurred, but they also had a new parking requirement that they couldn't meet.
When they requested the expansion, the expansion would have required 9 additional parking spaces. At that point in time, they requested a parking reduction permit, and the the then zoning administrator approved a parking reduction permit, allowing for the expansion without providing any additional parking spaces.
Then at some point, that parking expansion, wasn't it revoked, or it changed because of additional
Correct.
configuration of the building or something?
The expansion of the restaurant, was approved for the parking reduction. They did not follow their conditions of approval. There was a great impact, and there was a great negative impact to the surrounding neighborhood. I mean, and it appeared that particular restaurant, Montrose Collection, rather than operating as a restaurant with incidental banquet, was operating primarily as a banquet hall as opposed to a restaurant. And the parking impacts of a banquet hall are much greater than a restaurant would be. And that's reflected in our zoning code, because a banquet hall essentially has a parking requirement of 28.6 spaces for every 1,000 square feet, whereas a restaurant requires 10 parking spaces for every 1,000 square feet. So the zoning code reflects an increase in parking demand for a banquet hall versus a restaurant.
Thank you.
But they were operating illegally, unpermittedly, as a banquet hall.
I have a question. That question is, you keep saying that this is an increase in size from the original restaurant. And actually, it is an increase in size from one restaurant, but it's a reduction in size from what Montrose had of 800 and something square feet. So why are you referring to it in both ways? I think the inconsistency is very confusing to us.
In the 2005 approvals, there was an expansion of approximately, I believe, 1,200 square feet.
Mm-hmm.
So they essentially took over the entire adjacent office tenant space. They were approved a parking reduction for this expansion.
Mm-hmm.
When the parking reduction was revoked by the City Council in 2009, that expansion is considered null and void. Or I should say the parking reduction is considered null and void, and because the permit is revoked, they do not have grounds for the expansion.
So they are using what was the original restaurant approval before the Montrose Collection went in there.
So what they are requesting now is, as part of the 2005 expansion, they created handicap-accessible restrooms of approximately 430 square feet. What they're requesting now is to use those 438 square feet of bathrooms,
And nothing
keep
else
it
that wasn't.
for the restaurant, convert what was previously converted as a restaurant expansion, but turn that back into an office tenant space. But yet, because they would like to keep these restrooms, it's considered an expansion of the restaurant. Because again, the 2005 expansion, because the parking reduction was revoked and voided, and the CUP, or the zoning use certificate, was revoked by the zoning administrator, this particular restaurant has no grounds towards that 2005 expansion area.
Okay, so my final question here is on our sheet A20, is N unit the unit that is being returned back to an office and previously was the restaurant area?
And forgive me, I'm going to actually go up to, if you see here, this was the entire space that was approved for the expansion in 2005.
This is being vacated back to office.
This area, 790, approximately 800 square feet, is being converted back to an office use, and they are requesting to keep these restrooms for the restaurant.
Okay, thank you.
Although, actually, I might add that in point of fact, we don't know for sure that it's going to be an office. It's probably most accurate to say that it has rights to be used by something which has the same parking demand as an
All right,
office,
thank you.
And where's the beauty salon?
which is almost nothing.
That's the one.
Shown down here. So it's office, what previously was an office and now went through the changes. the restaurant in the corner and the beauty salon at the front facing the street.
And what was the violation that they did that ultimately led to the revocation?
I don't know if that's part of this, and maybe if that, I mean, we can talk about the past use, but I think we need to talk about the present use.
Question should have been, what wasn't there?
I'm happy to let you entertain it, but I think that we've,
So is it the same owner
no.
from back then? No.
It actually is the same owner. It's a different operator.
Different operator of the restaurant?
Correct. So the business operator for Montrose Collection is no longer at all on the premises. They have left completely.
The way the floor plan layout is laid out with all these booths and tables, are these required to be fixed, anchored, or are they free to move around, rearrange it?
What they are proposing with those interior dividing walls, the half walls,
Yes.
and the layout, it would essentially, the restaurant layout would have to essentially stay the same. They would not be able to come in at a later time and remove those half dividing walls and put in tables of 10, because essentially that would, I mean,
Right.
and be used. Again, they are limited right now. The zoning code specifies that this would essentially have, or I should say the application specifies, this is to be a new restaurant. It is to follow the guidelines of a new restaurant. It can only have private parties up to 30% of the floor area. If they ever go through some sort of metamorphosis that's not permitted, not sanctioned by the city, and they turn into a banquet hall like Montrose Collection is, we would go through the same process all over again to revoke those permits.
Do we have more questions, because we have not even heard from the applicant of staff?
Good.
Or the
may I-
appellant, I'm sorry.
Sorry, I do need to
Mr. Foy?
jump in a little bit one last time, hopefully. Villia is correct that the approval does require people to adhere to the plans that they've submitted. However, there is, the zoning code provides that for minor changes which do not substantially change the operation, someone can come in and request at least some minor modifications as long as it's consistent with the approvals that were given. So, I mean, if someone chose a layout of tables, it's not necessarily, and we go in later and they've rearranged them, it's not necessarily cause for revocation. As long as it's not a change which changes the nature of the building or in some other ways leads towards a violation of the conditions of approval.
The intent.
And the second thing I wanted to address is the easement that Villia was talking about and the covenant that we would require. It's probably legally best if we do not have the city be a party to the covenant. We probably cannot require that it not be changed without the city's permission. The city attorney can still approve it to form, and what we can do is add that they have to notify us if the covenant is removed, in which case it could be grounds for considering revocation at that point.
Is that one of the conditions in there now?
The city attorney is making some modifications right now to
Okay.
the condition.
All right. Any other questions of staff before we go to the appellant? All right, we have an appellant, and I think I have your name here, Mr. Fred Teichert.
That's one pronunciation. Yeah. Teichert, I go by.
Okay,
My wife goes by Teichert. So,
all right. You'll give us your name, and you and your team have a total of 15 minutes to present your case to us.
all right.
Would you have-
It was interesting. First of all, good afternoon, members of the Planning Commission. Thank you for having me here. And I
Your name and address.
My name is Fred Teichert, 2510 Countryside Lane, La Crescenta, California. Longtime resident of Glendale. I am here to appeal the decision that was previously made by the hearing commissioner. And I have a paper which I'm sure you all have here. Do you have a copy of this? I thought I would hit some of the high points, and then if you have any questions about anything that perhaps was already discussed or anything new, I'd be happy to answer them. This paper I wrote up, if you would, I would like to go through it with you. The Chandelier restaurant that I'm opening is the oldest existing restaurant in Verdugo City. It's been there for over 60 years. And in the prior 5 years, the previous restaurant owners failed to obey all the conditions of the conditional use permit. And finally, through the city and the federal bankruptcy court and the city attorney, the restaurant was finally closed because it was operating mainly as a banquet hall and not as a full-service restaurant, which is what we are going to have. We are going to have a full-service restaurant. Now, you were talking or discussing about the layout of the restaurant. We have it, we adapted some changes. We put in booths, and we removed what was previously a dance floor and a small stage. That was removed just to show our good faith that we are not planning on having banquets in there. We understand the 30% rule, which apparently the previous owners did not have any understanding of 30%. So what we have done to try to, we've tried to follow all the recommendations and suggestions that we got from the city planners and from what we have been told. We are reducing the restaurant floor size by almost 800 square feet, 794. We've removed the stage and dance floor, as I mentioned. We've added booths and partitions, permanent 6-foot partitions, to show that we are not planning on having large banquet tables, as Villia mentioned, with 10 people seated around. Number 4 on my list here, we have added a mutual easement between our property and the adjacent property. Now, we originally filed with the county an easement that was an indefinite easement. We thought that was the better way to go because it might be 20, 30, 40, 50 years before anybody's going to develop that property. But it was suggested that we go for a definite 5-year period of time, and at the end of 5 years, renew it or make some changes, off-site parking or whatever needed to be done. The restaurant that we're opening is a full-service restaurant which delivers a unique dining experience. It is much needed in the Verdugo City. There are really no dine-in restaurants in Verdugo City. It will be a big plus for the community. There are nice buildings, nice people in the area, and we really are going to open a top-quality restaurant. I don't know if you were given one of the menus, but it's a very extensive menu. If you have any questions on the menu, my operator, Zev Nazarian, will be happy to answer that question. Next paragraph. The only reason the city of Glendale closed down the previous owner was because of the violation that they were operating a banquet hall. And I can sympathize with the people in the neighborhood with a banquet hall. As a matter of fact, my granddaughter had a reception there after her wedding, and there were 230 people almost there. And with 230 people, there's not parking for 230 people in the area. And on that type of occasion, you do need to find other parks. And we are not, our full capacity, I think, is like 120 people is maximum. And that's all we're going to do. So we have already recorded an easement with the county that apparently the the city thought it would be better to have a definite period of time, which our adjacent neighbor, the Carnegies, are very willing to go along with that easement. They've been very cooperative, willing to help, and we had to survey the property and go through and get it all notarized and recorded and everything. This is actually the second time we're going to probably have to do it here. So after considering conditions placed on our permit, okay. Yeah, the next one is kind of a little different off topic. It's one of the conditions that was placed on our conditional use permit, and that is that we operate from 5 o'clock to 11 o'clock. We request that the lounge area that also serves food to operate should be allowed to stay from 5 o'clock, 5 p.m. to 1 a.m. This is consistent with surrounding restaurants and similar situations. I have complied with all the city's requests and demands, and we are trying to be good neighbors. We have talked with many of the people in the surrounding area, the businesses, and they have been most cooperative in every respect. So that is what I would respectfully submit to the commission at this time. Now, are there any questions you might have about some of the topics that Villia brought up earlier?
Or does anyone have a question for Mr. Lee?
I just need a little clarification because I think during the presentation I heard about the ownership of the restaurant versus the operator of the restaurant. And you mentioned here in your submittal that you've been operating your restaurant for 60 years. Are you relocating from other location to this new location now?
No, I have not been operating it for 60 years. I've been a school teacher at Hoover High School for 50 years.
In the letter.
It's essentially a restaurant that I'm opening is the oldest existing restaurant in Verdun City. It has been a full-service restaurant for over 60 years.
The original restaurant was in, I think it was 1953 or 54 when it was originally a Mexican restaurant.
Sorry.
Okay, so just for the clarification then, so this was original restaurant. Is that what you said?
Yes.
At this property?
On the property, yes.
On the property,
Yes.
okay. So now you're going back to using that same name. Okay, now, so as far as the operator then, and the owner relationship, although the Montrose collection is no longer in the picture,
That's right.
I've been here when that case came before me, and
Yes.
I know the history of that
Yes.
banquet hall.
Uh-huh.
I just need to find out, what is the relationship, the ownership of the restaurant versus operator of the restaurant. You're saying that you mentioned in your also testimony that, the previous operator or previous owner was, or neglected, directions or, to follow, the codes and so on. So can you explain that a little bit?
Well, I'm the owner of the property, okay? I had nothing to do with the Montrose collection. That was, I leased it to the Montrose collection in 2005, I believe it was. And then they went in and made many changes without my permission. I should have been more on top of the...
Oh, okay. So then you are the property owner.
Yes.
Now you want to become the operator of the restaurant?
I am going to be the owner of the restaurant, and I have an operator, Zev Nassarian, who is a cordon bleu chef, and he's going to be the operator of the restaurant.
Okay, thank you.
Yeah.
What are you saying?
He's asking.
Just to further that same, so the enhancements and additions done to the property,
Yes.
what did you know, how did they occur without you being involved in it? What happened there?
Well, they came in and told me they wanted to do an expansion, and they got the legal permits and everything for the expansion. So I thought everything was all right. And then they went in and they pretty much, all they told me is they were going to expand, and it was all right. They had the city approval, they got the permits, and everything was 100% legal. But what they didn't tell me was that they were going to have banquets only, and to try to cover their trail a little bit, they put a sign up out in front of the restaurant saying, well, we're not open at the present time, but if you want to, you can make a reservation and we'll come down and open it up for you. That was their open to the public. They never had it open to the public like they were supposed to. And we are trying to run the restaurant as a full-service business who gets along with all our neighbors up and down the streets and surrounding neighborhoods. We've talked with many people, and they think what Verdugo City really needs is a nice quality steakhouse and social lounge. And we're not having dancing, we're not having big bands, we're not having banquets. We are having a nice, quiet steakhouse where you'd be proud to take your friends to.
Okay, that answers my question. Thank you.
Thank you.
Any other questions of the appellant? All right.
But what I would like to just finish in saying that it has been in operation since the 1950s, and there has never been any problem with the parking or problems in the area until we had the banquets, and that was a big problem. Okay?
Thank you, sir.
Thank you.
Also, I just wanted to note, I just distributed a copy of the description of the restaurant, their business description, as well as a copy of their menu. And this was provided to the zoning administrator at the planning hearing officer meeting back in April. So this was submitted as part of the record for the planning hearing officer, or planning hearing officers.
It's good to see the menu because I wasn't able to get the menu from the Montrose collection before.
No. So it's, so this, yes, definitely. No, that should be offline.
The menu now.
So if anyone else would like to see it, I have a copy of it. So.
Thank you.
Thank you.
Thank you very much.
And I'll also like to make note of it that we received an email this afternoon from Ms. Sharon and Mr. Robert Thompson, who live on Hermosa Avenue, and again, they are opposing the conditional use permit and the administrative exceptions based on the history of the project site.
Thank you. Gentlemen, we can, if you have any questions, we can now ask the planning hearing officer if you would like to ask any questions that were not answered in the packet. If not, we do not need to ask her any questions.
Are there any other speakers?
Well, we don't go to that yet.
All right.
Any questions of the planning hearing officer? Okay. Now we will go to public comments. We had Fred already. Benjamin Oseguera. Would you like to speak, sir?
Yes, I
You
would.
can correct my, and please give us your name
I've had problems
and,
with that. Even with when I was in the military service, they would misspell my name also, so it doesn't matter. My name is Benjamin P. Oseguera, and I'm a resident of Locking out of Flintridge, and I was born and raised there, and so I'm a retired Marine, so I've gone to various places, went to Vietnam and all that stuff, was a deputy sheriff for a while, and I've worked with abused children. And I used to come down, since I'm retired, I'd come down to Montrose, and at that time, the operator, Siv, I used to go down there just about every other day, at least, and have a cup of coffee, and that's where I met, of course, met Siv, and also I met Fred, and they were casual acquaintances, but our relationship became friends, and I consider them still good friends. And I found Siv, an operator of a coffee shop at that time, to be very industrious, very caring, very conscientious about what he was doing. And eventually it migrated to where he had sold his property to move in as an operator here at the Chandelier, which I don't necessarily like the name. I have another name, but they don't approve of it. But anyway, I found Sev, the operator, to be a very extremely dedicated, focused, a good friend, and he's always looking at the bright side of things, and he follows regulations extremely well. Fred, I found, also I consider a friend, to be very conscientious, dedicated, and he works very well with the general public. Both of them do, in fact, and I'm proud myself of having those two gentlemen as friends. And that's all I wanted to say. And I think they would provide, and I've had some of Siv's food that he's cooked for us, and it is extremely good.
Thank you, sir.
Thank you. Appreciate
Any
the commission.
questions for
Thank you.
Mr. Oseguera?
Oh, I'm sorry. Was there any questions for him?
No question.
No. Thank you.
Thank you for your service.
Thank you.
Next, we have Sen Nasavarian. All right. You have very beautiful handwriting, but I can't read it.
Thank you. I'm actually the operator and the chef of the restaurant. The idea of the restaurant was actually my idea. It is a themed restaurant. I don't know if you guys would like to know. It is a 1920s themed restaurant. The inside is fantastically decorated, and the way it's designed, it takes us back to the early 1900s era. And the bar, the food, we use all 95% organic products for our food, and the menu is very simple but extensive, and we're there to serve everybody. And the idea of the restaurant was more of a social club, which is back in the 1900s. People wouldn't just go to a restaurant and just dine. They were just there to dine and socialize, which these days, people there who are over 30, they don't have that chance. Their night out is just go to dine and just go home. But this is the idea that we want to have all residents in Glendale, in Montrose, and Verdugo City to come there and not only just dine, but interact with the neighbors and the residents. And it's basically, it's a funner place, and for people that they're elder and they want to go out have a drink without getting involved with the 21, 22-year-olds at a bar. That's the idea of the restaurant. If there is any question, I would love to answer.
It's not a question, it's a statement, comment. It's the wrong time of the day for you to talk about food here.
Well, you can stop by any time, and I will be glad to come for you. Thank you for your time.
Thank you very much. Kevin Howe.
You got that one right.
1 out of 4.
I have been a customer of Mr. Nazarian's prior restaurant that was located just down the street, and over the course of the couple of years, I own a business in Montrose and have been there for about 10 years. Stumbled upon his place in my quest to find interesting new places to eat in the area, and as a result of finding his prior restaurant, really became a regular there because of the quality of the food and also the fact that he was so personable. So, customer and have become a social acquaintance, and that's also where I met Fred as well over the course of hanging out in Sev's prior restaurant. I have been inside of the proposed new restaurant. These guys have done an extraordinary job in terms of creating a very elegant place. I don't have a copy of whatever you have in front of you or whether there's pictures of it or not, but they've really created a very special environment. And as a business owner in the Montrose area, there's nothing like it. From time to time I have to take clients out and entertain them. Oftentimes I'll head to Pasadena because if you want an elegant sort of a dining experience, there's just nothing quite on par with that in that general vicinity. So I think it would be an asset to the neighborhood. And I can't speak to the parking requirements. I know rules and regulations are there for a reason. Just as a layman sitting here and listening to it all, it sounds a lot like there's 3 parking places that are being required because they have handicap accessible bathrooms, and I'm probably far oversimplifying that, but just as a business owner and a guy who goes out to eat a lot in the area, I would just like to say that I'd sure like to see it happen. These guys have invested a lot of time and energy and money to create something special for the community, and I'd sure like to see that happen sooner versus later.
Where was this prior restaurant?
Also on Honolulu, just a tad east of there on the opposite side of the street.
Is that still active? Because now I'm
It's a bakery
interested
now.
myself. Okay, got it. All right, thanks.
Sure. Anything?
Thank you.
By the way, you don't have to travel all the way to Pasadena. We got great restaurants on Honolulu and also downtown Glendale.
Yeah.
Yes.
Just a
She
suggestion.
can give you a list.
Well, one,
Just a suggestion.
Thank you. I have no more cards for us to have individuals speak. So what I can allow is the staff to add anything to this. So seeing that, we will close the public portion of the hearing and we will deliberate.
I could go.
Commissioner Lee.
Yes. Thank you, Chairman. We had this restaurant, I guess, back then, banquet hall, come before us because of the, all the violations that's been noted in the past. What I wanted to make sure was that we do not have the same operator just changing the names and really, I guess, take us through the ringer again. But my, I guess, suspicion or my question that I had has been answered in that, property owner is not at fault when there's a violation with the operations of the business. And what I'm hearing is that the new operator that's coming in has operated in the area of a nice restaurant, and I guess good enough to make my mouth watery when I heard his food selections. So I am planning towards approving, so overturning the hearing officer's decision and approve the request to overturn.
Thank you. Commissioner Singh.
I have no problem approving the conditional use permit as well, and would move forward with it as well.
All right. Mr. Sheets.
Yeah, I have, easement concerns me, only because it's not permanent, and things could happen. But that area, that corner, and those shops and stores have been there for many, many years. I've used the restaurant in the past, the Mexican restaurant, many times when I worked up in that area. So I think the use is perfect. It's needed. I think the owner's trying to use what was built there, which has created the situation where we need the permit approval. But I don't think that the intent is to try to add something or to do something unusual. So I think that's good. The historic use is as a restaurant. We need good restaurants. So there are not a lot of people that spoke for it, at least here. There was nobody that spoke against it, but we did have a letter in opposition. But I think if it's a good restaurant, it serves a good purpose in the community, the parking will take care of itself. I do just have concern about that easement not being permanent, because it could change all kinds of things, but I guess that's why we're making it a document that's recorded, and it gives us an option to review that situation. So It's not one of those things, it's just, to me, it's not a slam dunk, but everything that I'm seeing in here leans towards approval, towards reversing the previous decision. So, I have.
Thank you. Mr.
Certainly. I can understand the apprehension on the part of the letter writer after what they've gone through with the previous business. And truly, it's, they're not at fault. I mean, having seen what they've seen. I will tell you this, though. This is why, I encourage this city attorney, and I heard Mr. Foy, or at least this is what I extrapolated from the comment that he made, that they really don't want to be a party to the agreement between two private parties. But they do have a lot of discretionary power to make sure that issues like this, like Montrose Collection, would not surface or rear its ugly head again. And so, having said that, I'll be very honest with you. If this is going to be a steakhouse, and then I won't have to travel to the other steakhouse to La Cañada. And it is a good use, and very difficult for me to see how a steakhouse would morph into a banquet hall with the booths and so forth. I do have one comment to make, though. It's true that it's 4,000 semi-hundred square feet restaurant, and it's true that the application of parking per 1,000 square feet, we have a set number. But practically, when you look at it, obviously, you're not going to have sitting or congregation in the restrooms. Well, you may, at least, let's just assume that you won't. Or in the hallways. So, this administrative exception is logical, it's acceptable, and I think there is a reason why there is a place for it in the code. And when you do the calculation to the total number of the parking spaces, you're looking somewhere close to about 10.5% to 12% difference, which in my opinion is a minor difference. So I'm all for it too.
Thank you. Any other comments? I too. Yeah. The public, we're not taking staff comments anymore. Right. I will bring that up. Thank you. I would like to have the condition where the notification is, if it is on number 25. That's, well, we have staff time, and then we have the time that's closed to the public hearing, and so why don't I talk about it first, and we'll see if you covered it. Notification to the city, and if any changes to the existing 5-year easement occur before the time that it expires. Are we going to change that? And that's what you're going to hand to us?
If you don't mind, and again, forgive me for not making this comment earlier because I didn't know where the board was heading, but it sounds like the board is heading towards approving the conditional use permit, and so I did not want to make this comment prematurely. If the board is actually considering approving the conditional use permit, the city attorney has quickly drafted a revised condition number 25, if you'd like me to hand that out at this point in time.
Sure, please do. So I've reopened the public hearing for the staff to hand this out. There you are. What is added to it for everyone who does not have this is at the very end of it, it indicates that the applicant shall provide proof of recordation to the Community Development Director and shall notify the city in the event of any modification or removal of the REA. That was my question. And now I would like to comment. I'm closing the public hearing again unless... Is there anything else?
One last one last quick comment, and this is, forgive me, I don't want to interject, but there is on condition number 7 of the proposed conditions for the CUP, there are hours of operation that were proposed from 11 a.m. to 11 p.m.
Yes, I will be talking about that.
All right,
before
thank you, then.
Thank you.
Thank you.
And I would just like to correct a misstatement I made. I had said earlier that Montrose Collection was allowed to have banquets. They were not. I went and looked it up.
All right, they were not allowed to have
was-
banquets.
To the degree it makes any difference to the commission.
All right. The reason I asked about the condition there, and I was going to go to the hourly condition, I actually eat frequently in Montrose, and I am not in favor of a lounge being open till 1 o'clock. I think the existing conditions that are here are appropriate for its adjacency to the neighborhood. I want to say that I know that the neighbors who lived around the Montrose Collection are rightfully anxious about anything that happens here. And I think that staff has addressed a lot of those concerns. I think the original decision by the planning hearing officer was appropriate and brought about a change so that when the appeal was brought to us, it was remedied. The concerns were remedied. To me, those are the way that we get good decisions that are made outside of these public meetings here, so that when we do get to look at it, we see that there has been a responsiveness on the applicant's part. Because of that, I feel that I can support the applicant, the appellant, in their request to have this appealed. So we have several choices. We have several choices there. Did I address your question? Thank you. Or your
Those were just the two
issues?
comments, correct?
Okay.
Yes.
And if anyone else would like to talk about the hours, if they have a different opinion than I do, please say so.
I mean, I can understand. I think I could understand why the business would want to be open till 1 a.m., especially because of the type of restaurant they're trying to pull off, which is kind of unique for the area. And for that reason, I would be okay with it. And if maybe we could, and there's a lot of times when I eat at restaurants, and it might be really late, and I'm always really upset that the restaurant has to close really early. Now, if 1 a.m. is maybe too much, I would be okay with making it at least midnight, if there's any other support on this commission to do that.
Can the public make a comment?
No, they cannot. But thanks for asking.
I have no problems with closing at 1 a.m. The California law allows you to open until 2 o'clock, for alcohol sales or any beer and wine sales. So having the lounge just open till 1 o'clock, I have no problems.
I agree. Considering all the factors that came out in the hearing, the type of restaurant we're talking about, the intent of the theme, I will say, as Chairperson Landrigan stated, I understand the concern of the residents locally, at least as much as I can. I do know that it was extremely terrible when the Montrose collections were there. It was a pretty bad time, and they spoke out very clearly. But I think if we can trust the fact that this is going to be a themed restaurant, the parking will be different, the parking requirements will be different. I would give them the benefit of the doubt. The intent is there to have a good a local restaurant, and there has to, I vote in favor of the fact that we give them a chance to stay open till 1 o'clock, just for the patrons' sake.
Mr. Storian.
On this issue, at least with a probationary time, I agree with Commissioner Landrigan, Chair Landrigan. There is history, unfortunately, and I know we don't have to consider this, but there is history behind this. And there are neighbors. And if the operator is capable of proving its neighborly or good, being a good neighbor, then I would not have a problem extending the time. But initially, at least on a probationary basis, and I don't know how we're going to word this. I wouldn't mind. I side with Chair Landrigan on the hours of the operation.
What about an option of doing the late hours on the weekend? Friday, Saturday? I mean, that's just an option. I just put it out there for
I would
thought.
be open to that consideration because I think, frankly, that might be more realistic.
I think I would lean that way.
I'll go with that.
That makes sense to me.
Direction too. Everybody agrees. So weekdays 11 p.m., weekends 1 a.m.
Correct. And then I would like to let you know what our options are. We have a lot of options here. We have the option of finding in favor of the appellant, which it sounds like we are leaning toward. We can find in favor of the planning hearing officer. We can make no decision and send it back to the planning hearing officer, or we can continue the map. So I would...
Madam Chair?
Yes, sir.
Also, we have two motions here, so do you want to entertain each motion separately, or are we lumping it together, or what?
I think we need to do it separately for the AE and the CUP, am I correct? So, would you like to make the
Yes.
first motion,
I'd like to make the first motion.
Commissioner Lee?
Motion to overturn the planning hearing officer's denial of PCUP 2011-21. I move that upon review and consideration of all materials and exhibits of a current record relative to conditional use permit case number PCUP 2011-031, located at 2833 Honolulu Avenue, and having after conducted an appeal hearing on said matter, that the Planning Commission hereby overturns the planning hearing officer's decision and approves said conditional use permit case number PCUP 2011-031 in accord with the findings and conditions set forth below, A, B, C, D, and E, and conditions 1 through 25, in that condition number 7 be modified to include weekend hours, opening hours till 1 a.m. for weekends only. And for condition number 25, to include modified language that's been submitted by the staff today.
I have a motion by
Second.
Planning Commissioner Lee, and I have a second.
By weekends, you mean Friday and Saturday,
Friday
or Friday,
and
Saturday, and Sunday?
Friday, Saturday, Sunday, yes.
Uh,
I mean, Friday, Saturday.
Friday and Saturday only, correct?
Right,
That's how I
Friday,
had it
Saturday,
down.
right.
Okay, so Friday and Saturday till 1 a.m., and Sunday night through Thursday night till 11 p.m.
Yes.
Correct.
Correct. I have a motion by Board Member, or Planning Commissioner Lee. Is there a second?
Second.
By Commissioner Yosayan. In terms of roll call, Board Member Astorian?
Yes.
Board Member Yosayan?
Yes.
Board Member Lee?
Yes.
Board Member Sheets?
Aye.
And Chairperson Landrigan?
Aye.
And now it goes to the AE. However, the administrative exception, you have two motions before you. One is to sustain the denial, and the other one is to overturn or reverse the denial. However, you were provided findings in support of reversing the denial, yet it appears that the standard conditions of an administrative exception approval were not included. So if that is the direction you so choose, I could read into the record the 4 standard conditions for approval of an administrative exception.
I think that would be appropriate.
Okay, so with that said, the standard conditions for an administrative exception would be, 1, that the development shall be in substantial accord with the plans presented in conjunction with the application for the administrative exception, except any modifications as may be required to meet specific code standards or other conditions stipulated herein to the satisfaction of the Director of Community Development Department. 2, that all necessary permits shall be obtained from the Building and Safety Division, and all construction shall be in compliance with the Glendale Building Code and all other applicable regulations. 3, that the premises be maintained in a clean, orderly condition, free of weeds, trash, and graffiti. And number 4, that any expansion or modification to the business or location, which is different than what is represented as part of this administrative exception application, shall require a new application and constitute adding of additional floor area or physical change as determined by the Director of Community Development and Community Development Department. So those would be the 4 standard conditions for approval of an administrative exception.
Thank you. Do I have a motion?
I'll do the motion. We don't have a
We really don't
motion,
have
but
a motion.
I move that upon review and consideration of all materials and exhibits of current record relative to administrative exception, case number PAE 2011-023, located at 2833 Honolulu Avenue, and after having conducted an appeal hearing on said matter, that the Planning Commission hereby
overturns the planning.
Overturns the planning hearing officer's decision with the 4 standard conditions.
Okay, I have a motion by Planning Commissioner Sheets. Is there a second?
I do. Oh, right.
So I do have a second by Planning Commissioner Lee.
Roll call, please.
Roll call. Board Member Planning Commissioner Sheets.
Aye.
Planning Commissioner Lee.
I do.
Planning Commissioner Science.
Aye.
Planning Commissioner Historian.
With no excessive exuberance, yes.
Thank you. And Chairperson Landrigan.
Aye.
The motion passes unanimously 5-0. Thank you very much.
Thank you very much. So I would like you all to know that any individual not satisfied with the Commission's decision may file an appeal to the City Council. This is done by filing a notice of appeal along with a filing fee at the Building and Safety Division located at 633 East Broadway, Room 101, Glendale, California 91206. Any appeal must be filed within 15 days. We have our second appeal of the evening. Conditional use permit number PCUP 1206549. But I do want to ask the Commission if we want a short break.
I'm okay.
Are we all fine?
Yeah.
Just because
Lee is
Mr.
already-
Lee has gone, shall we take a
Yeah,
7-minute recess?
Quick, 5
It
minutes.
was 4 minutes.
4 minutes.
4.5.
Thank you. Okay, thank you, we're back. We are back, and we have, thank you very much. We have another appeal. It's conditional use permit number CUP 206549 for 806 East Colorado Street. I would like to have staff give us an overview, and I am opening the public hearing.
Thank you. This is a proposal to request to overturn the denial of a conditional use permit for alcohol sales at 806 East Colorado. This application was heard by the hearing officer on May 16th, and a decision to deny the request was rendered on June 8th. The hearing officer denied the conditional use permit primarily because of a lack of on-site parking, but also he cited the overconcentration of alcohol sales establishments in the census tract, which is one of the findings relevant to alcohol sales conditional use permits. This establishment had a legal non-conforming liquor license, which allowed the tavern to operate without a CUP for some years. But approximately 3 years ago, a prior tenant failed to renew or obtain a zoning use certificate as required when there's a change of operator, but yet continued to operate. Last year, the appellants leased the building under the assumption that the legal non-conforming liquor operation would still be valid. But upon staff's review of the history of the project, it was determined that the prior tenant, because they had failed to obtain the CUP, the zoning use certificate, and had continued to operate for over 1 year, because of that combination, the operation had lost its legal non-conforming status, and it was therefore necessary for them to obtain a new conditional use permit. The appellant subsequently applied for the conditional use permit, which was the subject of the hearing and the denial. The previous use had live entertainment, and based on the applicant's proposal, no significant changes to the layout, services, or hours of operation are requested as part of the current application. The existing site has no on-site parking places. Based on the fact that this tavern is proposed to operate similarly to the prior tavern operations, staff believes that there's no change in parking demand. There will be no change. Staff also believes that the proposed location is appropriate in that Colorado is a major commercial street where uses like this ought to be located. The overconcentration of similar businesses in the tract has not resulted in excessive crime or complaints about operations at this site. And there were no objections to the proposal by any city department. Based on that, staff recommends that the Planning Commission has the findings necessary to approve the request and overturn the denial. You have a motion attached for your consideration to overturn or to sustain. I would also mention that it was the applicant's testimony at the prior hearing, at the hearing officer hearing, was that the structure at the rear was not functioning as a garage, even though that's what it was built as. It was being used partly for storage by the property owner and by the tenant. This essentially makes part of the function of that garage a warehouse, which is not permitted in the zone. So if the Planning Commission is inclined to approve the request and overturn the denial, it may be appropriate for you to condition the structure be returned to its function as a garage and that the driveway be paved back to that garage area. The one other impact that this would have would be that the proposed outside smoking area would have to relocate from off of the driveway to the rear of the tavern. But it appears that there's sufficient room back there that it could meet code.
Where's this driveway you're talking about?
It's along the west side of the building. On the aerial photograph up on the screen, you can see me indicating it here. And on the plans up above you on the board, it's the black area to the left of the brown building. That's where the driveway is.
And that white triangle is
Like-
what?
Like an awning or something.
This area, this here,
That's the smoking area?
I was out there today, or yesterday evening, and I looked through the gate, and there's just a bunch of construction material. I don't think there's any structure back there now.
Excuse
You
me,
can't
I'm
talk.
sorry.
Have to wait.
It's not a public hearing yet.
I looked through the gate, there's no awning, there's no covered area, there was just a bunch of debris behind the gates. So I think this picture is basically just out of date.
So-
It sounds like the appellant can clarify it anyway.
How would they get to the back if that is being used as a smoking area?
How would
they get
vehicles?
Yeah.
Well, if you chose to, you could require that they pave that driveway, because it is a driveway that went back to this garage. By appearance, the garage looks like it was built in the 20s or maybe the 30s. It has old wood sliding doors on it. So it clearly functioned as a garage, probably with this as a driveway at some time in the past. It just needs to be, I think the area just needs to be repaved. The driveway just needs to be repaved. And then, as a condition, you just need to designate it that it be used as garage. But
Garage, you mean like parking or
Parking.
storage?
Parking. That doesn't necessarily mean they have to park a vehicle in there. It just means that's how they're indicating it on the plans. They agree to have it that way for permitting purposes, and that they agree to keep it that way and not store, that the owner, who is not a tenant, not operating the structure, he agrees not to store his materials in there.
Any other questions? Commissioner Lee?
Yeah, Madam Chair, I see the history of this project and also the reasoning behind, overturning the previous hearing officer's decision. But
Before you go too far,
Yeah.
do you have a question for Mr. Hamilton, because we still have the appellant to talk to? So this is about his staff report?
Yes.
Okay,
yeah,
thank you.
Right. But is it possible for us to hear from the hearing officer?
Yes.
I think he's here. Because what I don't see is that really nothing has changed here from, the time that when he was hearing this case, and now the new recommendations here, that, like in previous case, that we had some changes made, improvements made, that allowed us to kind of weigh in on those things. What I see...
The procedure, and we can, the procedure is that we have the staff do the presentation. We have questions for staff to present what's here. Then we ask the appellant to come up, and then we have the opportunity to speak to the planning hearing officer.
Oh, okay. Okay, so I'll wait till then.
Can we?
Yeah, sure.
We'll follow that procedure then.
But let me speak to the notion about the conflict, essentially, or the disagreement between staff.
I think we don't
Wanna
need
wait?
you to discuss that.
Okay.
We will, I think it's clear in your report, and we can have a discussion with the hearing officer afterwards.
Fine. Sounds
Okay?
good.
Any other questions for staff? You can certainly.
Is there is it proposed to do anything in the back? I mean, other than the garage, like for the back area that's kind of used for nothing right now?
No, there's no proposed function.
That's it.
Other questions? We will invite the appellant to come up. Now, there are two of you that I have as appellants. Between the two of you, you have 15 minutes total.
Great, thank you.
So if you will divide that however you wish. If you'll identify yourself, and
My name is Michael Guerrero. My address is 517 Caruso Avenue, Glendale, California. I am one of the two appellants, and I will be doing probably the full 15 minutes, not most of it. To answer Mr. Yessian's question, for the back, we actually were planning on landscaping and making it a fruit and vegetable garden where we would try to grow as much of the ingredients we use within the tavern to use within the tavern, because we believe in the locally sourced organic movement that's taking place in the Los Angeles bar and tavern scene. So that was the plan for that. That's why we labeled it on the plot map as green, which is landscaping area. So it would be with grass and vegetable beds and herb herb beds and things like that. We want to put lemon, lime, possibly orange tree back there. Basically, whatever we can grow in-house, we will grow in-house. So that was the plan for that rear area.
And the rest of your
Great, thank you.
presentation?
So we are appealing the hearing officer's decision to deny our conditional use permit application based on the contention that the officer refused to hear or consider certain facts before rendering his decision. First and foremost, the hearing officer refused or failed to consider that the proposed use is simply a continuation of an existing use that has existed on the premises for over 40 years. I actually have a copy of an occupancy certificate from 1972 when the place first started being a bar under the current owner. So, but for the failure of a prior tenant without the knowledge of the property owner to file a form required by the city, which is the zoning use certificate, the existing use would have been grandfathered as a legal non-conforming use, and no conditional use permit would have been required. No change of use was requested. No expansion of services offered was sought, and no addition to the building square footage was proposed. Had this been taken into consideration, the hearing officer's finding that our proposed use is not in accord with the land use element of the general plan because of an overconcentration of ABC licenses in the area would not be valid. The building, its use, and the corresponding ABC licenses have existed harmoniously with the community and the general plan for decades. The overconcentration of ABC licenses in the immediate area, which is common on major arterials, for instance, Honolulu and Montrose, has not resulted in problems sometimes associated with these overconcentrations. Per conversations with the Glendale Police Department, a couple actually, the immediate area is not in a high crime reporting district. There is 0% excess over the city averages for Part 1 crimes in that census tract. The proposed location and use have maintained a positive standing with the GPD. And, in fact, the GPD approved the proposed use without objection and with only the minimal and standard conditions. The second thing that we feel that the hearing officer did not consider, even though we presented it at the hearing, was that the proposed location and use have never had a parking lot or have never had any kind of deeded parking spaces, and despite this have coexisted with the area for 40 years without any record of parking or traffic conflicts, not only with city offices but with local residents. In fact, throughout this process, we've had to go through 2 escrows for ABC licenses throughout this because it was taking so long that our previous liquor license seller backed out, and then we had to buy another one. So between 2 ABC processes, the original conditional use process and the appeal process, there have been 4 mailings, 4 publications, 4 postings, and we haven't had any negative feedback from any of the local residents or city offices. And if parking were an issue, given the fact that this place has operated under the same use for 40 years, I mean, something obviously would have surfaced at this point. At least I would hope so. The location, small size, hours of operation, opposite of those of most businesses in the immediate area, and positioning on a major arterial with an abundance of unused metered parking during our peak operating hours will not infringe on the parking needs of surrounding businesses and residents. The hearing officer cited a lack of parking as a primary reason for denial. However, there were no public objections or objections from departments within the city to support this reasoning. Also, if there was an internal record within the city about parking or traffic issues, at some point in the staff report, I mean, we feel that this would have surfaced from one of the city offices, including neighborhood services, parking and traffic, police department, but nothing of that nature surfaced during the entire staff report production process. So this fundamental lack of evidence in support of the hearing officer's ruling indicates that the reasoning might be flawed. And finally, the hearing officer refused to consider that no city departments voiced any major objections or concerns, and all recommended approval of the proposed use. The staff report also recommended approval, and the applicants fully embraced and did not object to any of the conditions included in the recommendation for approval. In fact, the public response to this proposed use has been extremely positive and supportive. We also provided some letters to you guys that should be in your file there to show some of the public support. Had this been taken into consideration, the hearing officer might have adopted the recommendations of the staff report and approved the application. So those are the three main points that we feel that were not considered in the initial public hearing. Some additional things that I wanted to mention. First and foremost, in the staff report for the appeal, in the staff analysis of appeal, first paragraph in staff analysis says that this establishment had a legal non-conforming liquor license status, which allowed the existing tavern to operate without a conditional use permit. Approximately 3 years ago, a prior tenant failed to obtain a zoning use certificate and continued to operate. Last year, the appellants leased the building under the assumption that the legal non-conforming liquor license would still be valid. I actually wanted to address that because, in fact, it wasn't an assumption. When we first approached the landlord about leasing the space and we did our due diligence, we contacted the planning department, and we were told by a planner in the department that the non-conforming use was still valid. It wasn't until a few months later when they were digging through some archived files that they notified, once we'd already opened escrow on a liquor license, once we were already engaged in the process with a lot of time and money invested, that he told us it was our oversight, our mistake, but we missed it. But in fact, your legal non-conforming use was invalidated 3 years ago because of the lapse in the presence of a zoning use certificate. So it wasn't an assumption. We were actually told, and we have a voicemail recordings too, that where we were told that the legal non-conforming status was still valid. So that was one thing I wanted to bring up. The other thing that I wanted to just kind of reemphasize is that, again, police department, traffic, and neighborhood services did not express any concerns during the application process regarding parking overflow into the residential neighborhood. One thing that we did, and again, this wasn't maybe not according to the scientific process, but we just did a very basic observation where my partner and I went every day for a solid week to the location. And we did a count of the spaces, basically 2 blocks in either direction from the venue on Colorado and the side streets, but not infringing on the residential neighborhoods, just in front of commercial spaces. So basically, street parking spaces in front of commercial buildings. We counted, we all agreed that there were 108 available, and the most we ever saw during that whole week of going 3 times a day at different times where we anticipate our highest influxes of customers to the tavern, the most we ever saw were 58 spaces taken, which means at the very minimum, there's always at least 50 street parking spaces available in that space. And it's not a large venue, so even though we don't have a lot, I think there's plenty of metered parking to support our small use and our small operation without obviously parking spilling over and inconveniencing the residents, which is the last thing that we would ever want to do. And a couple more things that I wanted to kind of talk about very briefly. In the staff report, it was also mentioned that that again, this is a continuation of an existing use. We're not trying to extend or expand anything. The place has always been a tavern with live entertainment. If you guys want, I have the from 1972, the Certificate of Use and Occupancy that states that. So we're just continuing an existing business model. We just want to do it better. The space is in a state of deferred maintenance. It's basically falling apart, and we just want to kind of make it not an eyesore for Glendale, but we want to make it something that the city would be proud of. My partner and I come from an extensive background of producing live entertainment. So we do concerts and shows. We've done it for many years. And we always have to take our shows to downtown LA or Hollywood. Glendale doesn't have, it's not on the map as being a destination for people to go see live entertainment. There's bars here, there's restaurants, but there really aren't many places where you could see a live show and have a drink at the same time. So we just kind of want to extend and continue the business model that has been in existence, but again, we want to do it better with better cocktails. Previous bars, they had a limited selection, store-bought ingredients. We want to kind of embrace the natural, locally sourced movement, like I said earlier, and we want to do gourmet quality cocktails, good music, good sound quality, things like that. We want it to be a place where we would want to go see a show, and that's been our objective from the whole time. So, other than that. Again, just to reemphasize that there have been a series of 4 mailings, 4 postings, 4 publications without any residential or commercial objections. And that both times we've had recommended approval from the city and the planning staff. And so we hope that you'll reconsider the decision and overturn the denial. And if I have more time, I just wanted to show you guys, because I know that, you can get a lot of information from a floor plan or a plot plan or a two-dimensional, but I had one of my graphic designers do a 3D model of the space, so you can kind of get a feel for what it'll look like inside, and I can project it on that screen if you guys would like, so you can get a better feel.
Is it hooked up?
One of the major concerns when we went through multiple plan revisions with the planning department were that what guarantees do we have from you guys that this isn't going to be a nightclub, that it's going to be a tavern with live entertainment? And to show our commitment to our promise, we offered to build a permanent wall, basically cutting right through the middle of the venue, like a pony wall, with fixed booths on either side. So the big concern was that, we don't want you guys to put tables or furniture and then move it, and all of a sudden you have a huge dance floor. You know what I mean? We don't want that either. So we're putting a permanent wall affixed between two permanent structural pillars and permanent booths on each side. So, our small little dance floor, I think it's 168 square feet, will never expand. There's no chance of that happening. So, I'm going to do... Sorry, guys.
Yeah, got it on.
Yeah, let me just move it to full screen. And we will start over. 1 second. So this view that you guys are seeing here, this is if you enter through our main our only entrance through Colorado Street. So as you enter, what existed previously was a bar, a huge island bar, smack dab in the middle of the room. I have the old floor plan of how the space used to be considered or configured. You might have it in your files. If not, I do have copies. The problem is that bar being right in the middle of the room created huge fire hazard and flow problems, because you imagine if you have a bar in the center of a room and obviously you have people waiting for the bar, lines kind of octopus out of the bar like that. And so you have people, the entrances are blocked, all the points of egress are blocked. People couldn't move in there with the bar right in the middle. So what we're proposing is that we want to put this huge pony wall, as you see, right in the middle of your screen, extending from these two pillars, which can't be moved because they're structural pillars, and then fixed booths on each side. So I'll kind of creep through slowly. And what we want to do is move the bar from the center of the room to the right side, here against this wall. So we'll have a 3-station bar here, extending from end to end. Multiple bar stools there, shelves going up the wall. Those are the restrooms, male and female. They're both ADA compliant already. Spinning around this way, you'll see our lounge area where the live shows would take place. So if I rewind a little bit, you kind of see on the right side the front of our stage. It's a very small stage. Just accommodates small bands, nothing major. And then on that, basically the floor space you see in the center is the extent of the dance floor or viewing area, for shows if people are spectating. Fixed booths on either side, and also on the far end in front of our front of house sound booth, which is basically where we have the mixer, all the controls, the lighting controls, things like that. In that booth that you'll see above the U-shaped booth on the center right of the screen. If we continue through, it just kind of loops back around. You're seeing the pony wall right underneath the camera pan angle. And then we kind of move through the stage to the backstage area. This backstage area is going to be used for bands, for their equipment. Obviously, bands, they have instruments, they have equipment. This will be their staging area where they get ready for a performance. They have their own private restrooms. And then we'll have in this entry a maintenance closet back there for our janitorial staff. And this entryway you see on the right-hand side, that'll actually have accordion doors to cordon it off so that bands and performers can have their privacy. They need to change, they need to do makeup, they need to do various things to get ready for their show. And then back here, you merely have offices, storage, and then the entrance to the back out toward the backyard and our smoking patio. So it's a small venue. It's less than 3,000 square feet. So that's pretty much it. I just wanted to give you guys kind of an idea of what it would look like inside.
Now, before we have any questions,
Sure.
Does John Giovanzi want to talk?
I'm available to speak.
All right.
If you have any questions, as long as...
All right. Okay, just wanted to ask that. Now, Commissioner Lee.
I just have One small question.
Yes, sir.
Because in the report, it says small scale, and then you mentioned that, it's a small venue, but I consider anything over 2,000, 3,000 is not a small venue. And, on the drawing, it shows maximum occupancy of 179 people. And I know you did a kind of crude method of, seeing what the parking situation was on Colorado Boulevard. Obviously, the people that would come to your establishment is not family-oriented people. These are more like single people coming or happening type of environment at your tavern. So I don't know. My own personal thought is that usually if I go out, I go alone, or maybe at maximum may take girlfriend there, or my wife there.
Girlfriend.
I do.
But anyways, so I guess what I'm trying to get to is that 179 occupancy is not a small load, and you do have a lot of people driving cars to your place. So obviously, if you have 100 people at your tavern all the time, doing a good business. But that when you have something like that, when it was grandfathered before, that was not looked at. But when this case was before the hearing officer, he had to look at that. He had to look at what is the really the parking load in their area, traffic load in their area, and I'm also looking at that too, because I'm looking at the nature of the your veteran staff who's gonna come to your place. So that was kind of comment that I had. I guess it's not more of a question, but if I had one question, I guess what it was in your have you operated that before, or you're new owners?
We're the new operators.
The new
yes.
operators, okay.
We don't own the real estate. We're leasing the space from the landlord.
So obviously, then you do expect at some point in your business, to have your place boom and have over 100 people there.
Well, to answer your question, one thing that's a pivotal in our business model is that we're not touching any what you would call mainstream music genres. So we're not doing. None of our events are hip hop or pop. Top 40 radio type stuff. We want to focus on the lesser served subgenres of music. So, for instance, we just did a show that had we gotten our approval initially, we were going to do at Complex, but instead we had to move it to a venue in Hollywood, and it's right in our wheelhouse, which is our average events are going to be 75, 85 patrons, small shows, small bands, and the average demographic there was about 35 to 38. It was a band that was well known in the 1980s. So the people you're thinking will be at our venue, they weren't even born when a lot of the music we're going to do it was even out. So it's a little bit different. It's not going to be like a young frat party or anything like that.
Thank you for clarification.
I don't know if you've heard of the band, but they're called Information Society. They did a song called Pure Energy in the 80s. Like that's the type of stuff we do. We want to do really niche-y type different stuff. We don't want it to be a big meat market that you think when you think of
The what market, sir?
a meat market. so it
more like my generation.
maybe somewhere in between.
I do. Great. Now I was looking forward for something.
You wanted the meat market. No, I'm just kidding.
We serve all our generations up here. Commissioner Lee, would you like to continue?
Oh, no. Yeah.
Any other questions here?
From me.
Commissioner Storian?
So there is no food served.
There's
period.
no food. It's always just been a tavern with a Type 48 license. So, one thing we did. I'm cutting in.
Go ahead.
Oh, okay. One thing what we wanted to do, because the space really isn't configured to have a kitchen. There's really nowhere to put it, and to still have adequate storage and inventory space. We wanted to have like a mobile food operator maybe come and provide the food in front of the venue, and then allow customers to bring it inside if that's something that the commission. I don't know if you guys are aware, but right now the food trucks are very, very popular. all through LA. So
And I would strongly suggest that you check with
the city.
City of Glendale
Of
about
course.
the mobile food concept.
Okay. We were just considering that if that's something you guys would want, like if you would want us to serve food, we were trying to come up with solutions, but it wasn't part of our business model.
I can throw a couple of ideas at you, and you don't need to say yes or no to it, but
Mhm.
you have a lot of restaurants around you
Mhm.
that you can make arrangements for finger food or whatever it is. But, I was thinking about, for a moment, the ecosystem that you are trying to do in the back and be self-sufficient for, and I believe these are the ingredients that go into the drinks.
Yeah,
and so
produce.
forth. It really caught my eye and piqued my interest.
Yeah.
Then I thought, you don't need 3,000 square feet of planting for serving drinks. At 150 or 200 or 300 drinks a night. But having said that, I would seriously consider using the services of other restaurants in the city of Glendale, if that's what that falls in your.
It's something that we actually did consider, because there's a place that we're very, I guess we kind of would consider them a competitor. It's a place in Echo Park. It's called the Echo, and they do small band shows. And they have a partnership with a local neighboring pizzeria called Two Boots Pizza. So they have the menus up, they have the little table tents up, and they allow the customers to order, and then they deliver it right next door. So that's something we're open to, and I think it would be good, because especially in our particular tract, some of those restaurants aren't doing too well. They're not like the ones in the Americana or that are always busy. Some of them are pretty empty a lot. So we would be willing to do that to increase their business and their sales as well.
But I encourage you to do that. The second question that I have, and I understand the concept of the genre and the 80s and so forth. What provisions have you made for security when you have shows?
For shows, I actually one thing that I come from a background of doing big shows, bigger venues, things like that, and so security has always been my primary concern. In my business plan, I have a huge portion of it devoted to my security plan. So in addition to all the standard things, like all my security guards being licensed and registered with the state BSIS, Bureau of Security and Investigative Services, they're all experienced, they're all trained, they've all worked in similar situations. We also have a protocol in place where basically we want to have like one security guard per X number of patrons in the space. So depending, if we're just a small, like on a night when we don't have anything, again, we're not going to have shows 7 nights a week or even 5 nights a week or even 3 nights a week. We'll maybe have shows 1 or 2 nights a week, and other than that, we're going to be a bar lounge with maybe, some ambient music playing in the background or like a playlist playing or something like that. And, a lot of those nights it's just going to be like a happy hour crowd or a smaller crowd, 50 or less people. And so, in situations like that, there would be less. But then when we have shows, just from experience, we would know, okay, we're expecting, 85 people. So then we would ramp up. We'd probably have like 3 guards for that. You know what I mean? So it's something I've been in the industry for 9 years. My partner's been in the industry for 12 years. So we're very experienced as far as handling and planning for those sorts of situations. So.
Thank you.
Other questions?
I think I would add, I think you guys have like a really great opportunity to do a really cool bar, like you're saying, because there isn't really much in Glendale.
Not in Glendale.
And I think the latest one, which is really cool, is Neat on Pacific, and that's kind of similar to what you guys are doing. I think I would find it to be the most similar. It's a small location, and they have music playing all the time as well. They have live bands who perform there. One of the other opportunities I think you guys have is the space that you have right on the side, which may not be used as a driveway. You could put bike parking there, and it can be encouraged for people, especially the younger people who are going to be coming here, to come there with bikes instead of driving there, and then take up a lot of the parking space on the street.
That was actually something about 6 months ago when we first started the application process for the CUP. I believe we submitted in March, but we started working on this in like January. One of the first people we called were the Bicycle Advisory Committee for Glendale, and we asked them if they would be willing to put in bike racks for our venue, because a lot of our customers do ride bicycles. Coming from all the local communities as well, Eagle Rock, Silver Lake, Los Feliz, places like that. They love bikes,
right?
And we've already opened that dialogue, and that's something that we're really, really open to.
Yeah,
So.
because I think the city would be able to put bike locks on the sidewalk, but that sidewalk looks really small.
It is kind of narrow.
So I think that private area on your driveway, which I'm not sure if the city could put bike racks there or not.
We could even
But
pay for them at our
that
expense.
presents a really cool opportunity that you can put like these really big, interesting locks where it would really encourage people to
We could be like
bike
the
there. And
bicycle
then
destination.
and then with well lights and everything, I think it would be really cool opportunity in that area.
So outside of helping him with his business plan,
Thanks, guys.
do you have any other questions of the appellant? Because
Do you have dress codes?
Of course, I mean we're a place we don't want to be exclusive in any way. We want to be very inclusive. We want everyone from people coming from other neighbor communities to people coming straight out of work, or just people who live around the block to be able to come out and just have a drink and listen to music. That's our whole objective, and that's been our objective from the get-go. So.
do you have any other questions?
No.
I do have a question. Would you have more than one show a night typically?
No, it's one show a night, and the reason being is that when you do a show, especially if you want to do a show right, you have to do load-in of equipment, you have to do sound check, things like that. So there's really no way to do. Again, we're about everything we want to do. We want to do quality.
Would you do 2 sets, sell a different set? You're more than welcome to come up, but you have to identify
he does the
yourself,
booking and promotions. I'm more like a
John.
logistics
Say,
guy.
I'm John Giovanni.
John Giovanazzi. To answer your question, normally no, but there would be a small exception for this on the weekends when we could do like a daytime show and then an evening show. Either with the same artist or with a different artist. I have seen that done successfully at a lot of places, and we have definitely discussed that. But it's not like it's not in our plans to actively seek to do double bookings in one day, just because we're both going to be working this ourselves, and we do like to sleep.
One other question. I know that we were talking about this as a music venue. Is there other entertainment? Would there be comedy shows? Would there be other
There actually would be.
like spoken word stuff like?
We're not. To address your specific question, we do plan on doing comedy shows. Both Michael and myself have family members who are stand-up comedians, and
I do
probably
too.
shunned at Christmas if we didn't allow them to do stuff. So we have promised them that they would be able to do comedy shows, and it's something that we do plan on doing. Karaoke as well, trivia, and that goes more towards the stuff that's geared towards the people who live in the actual neighborhood that we're in. There's not a lot of places for people who live in that area to go to at night and do things, have a drink and, some kind of entertainment. So stuff like, no cover charge karaoke events, no cover charge comedy events, no cover charge trivia events are on our plan for, on a weekly basis.
Mr. Commissioner Lee.
Now, on this conditional use permit, do we have any time, span as to 5 years, 10 years?
2 years.
2 years? Is that
right
what it
here.
says?
There was some.
Right
Oh,
here.
okay, shall
Wow.
be. Okay, thank you. And then what about the time of operation?
Yeah, what are your hours of operation?
Monday through Friday, 5 to 2. Obviously not till 2. We would, do a normal last call at 1:30. All drinks cleared out and picked up by 1:40, which is standard for establishments like this, and then start getting people out into their cars and home safely
You
by
said
2.
Monday through Friday.
I'm sorry. Excuse me.
What happens on the weekend?
Sunday, Monday through Thursday, and then Friday as well, and then Saturday, Sunday would be noon to 2. So we were hoping to be able to do some kind of daytime things during the day, just on Saturdays and Sundays. But on weekdays, 5 to 2.
Should that be part of the condition, or?
Well, I don't know if that should be part of the condition if it's in there, but I also don't know, does the city allow entertainment to go till 2? I don't know what the city codes are, but I'm sure we'll find out. Any other questions? I think that does it. Thank you very much.
Great, thank you.
All right. We have the opportunity to have the planning hearing officer provide his rationale for the decision, and we can ask him questions.
Would you like me to talk about that?
Yes.
Okay.
We're asking you to do that.
It's pretty obvious that the two main reasons, as Mr. Hamilton pointed out, are the lack of parking and the overconcentration. So how did I get to that point? A project like this has a lot of similarities with our banquet hall issues. So I'll go back to 2002, when a lot of the rules were changed and definitions like nightclub and banquet hall came into existence, primarily at the insistence of our police department, who said there are different issues. Okay, so one of the things that they lobbied for was this comparison with the crime rate and this concentration level. And the basic philosophy was we either need more police or we need fewer. We don't need any more alcohol serving establishments in Glendale, and maybe in some areas we could do with less. That was the whole background to that. Otherwise, we had all the control we needed prior to that to give people a chance to operate a successful alcohol serving operation. So if you look at the regulations, it provides for us, even if somebody runs afoul of state liquor license, it gets suspended. The goal is to really put them out of business. That's what the goal of the regulations were. So while it's unfortunate that things happened here where they lost their legal nonconforming rights, it forces you into this conditional use permit process, which then requires that we deal with these pesky findings, one of which involves adequate facilities, including parking. So, I mean, if you look at my denial of the finding D, pretty much explains what you need to know. In fact, the applicants originally filed as a nightclub. That's what they checked off. And when the then case planner started delving into that, it was realized that they couldn't operate as a nightclub because it would have generated a higher parking requirement, similar to a banquet hall situation. So in working with the applicants, they managed to downsize the dance hall so they weren't no longer technically defined as a nightclub. So they weren't legal nonconforming with regard to the service of alcoholic beverages, as has been pointed out, but they are legally nonconforming as a tavern with regard to parking. You don't lose your legal nonconforming parking rights just because a year goes up. So, okay, while it's not the ideal situation, if they do have those legal nonconforming rights. So, we're back to the CUP findings, and this didn't seem to me to be a local bar that of a small nature. It's heavily entertainment-driven, shows, events. Again, 179 maximum occupancy, 52 seating capacity, dance floor, and 0 parking. So they testified that, number one, customers and employees aren't going to be parking in the residential neighborhood. But they didn't have any other arrangements. They were looking into discussions with adjacent property owners, which tells me that they really felt that they had a need for some off-street parking. However, as I mentioned then, and I'll mention now, they would have had that in place and applied for a parking use permit for us to consider that. I only point that out because I think they probably realize themselves that there's probably some need to have off-street parking. Colorado has a 2-hour limit up to 6 o'clock. As you know, there are lots of bump outs with red curbs. And there's a lot of competition with other commercial establishments. So I'm not convinced that residential neighborhoods are not going to be impacted, as I think the Commission has already surmised that the patrons aren't going to come in large groups, so there'll be a large number of cars. You will have up to 10 employees. If the band's going to unload, are they going to unload 2 blocks away, or are they going to pull into the driveway? Well, if they're going to pull into the driveway, you're going to have to pave the driveway, which you probably have to do anyway if you're inclined to approve this, as Mr. Hamilton pointed out, because if it's not a garage, it's either a warehouse, which isn't permitted, or it's storage for the restaurant, which in itself generates parking requirement, which they're trying to avoid losing their legal nonconformity. So you're back to make the garage a garage, pave the driveway, and don't store things in the garage. You can't force people to park in the garage, and then the smoking area would have to be moved somewhere else. Again, food is not, they said they might have packaged food, dance floor, and as I mentioned in the finding, if you were to build this place today, the code would require 30 parking spaces, which I think is pretty reasonable given the capacity. Not enough for really successful operation, and too much if you're not doing well, just like most of our parking requirements. So when your real demand is 30, maybe 30 plus if you're having a popular band there or other television event that they plan on showing, and you have 0, it really, as I said, it's hard to say you have adequate parking when you have 0 parking. And that's why I sort of was backed into the corner of having to make the finding. Again, it's unfortunate. There are other locations in the city that have parking where this would be more successful, or there are other locations like downtown that encourage entertainment uses where the parking is available in different means and the requirements are less. So this is exactly the type of use that we'd probably like to see in our entertainment district or somewhere else in downtown. But again, it's not that it isn't allowed here. It's just a matter of a parking issue. Their proposal was to have no on-site parking. I didn't think I had much of a choice in the matter in denying this request.
Questions?
Yeah, I do have a comment. The kink here, though, is the fact that prior, and here's the question, the use as a tavern before this, did it involve entertainment, shows, dancing, or not?
I'm not familiar with the details. Again, we had no discretionary permit in effect because of the legal nonconforming status. City clerk entertainment, live entertainment permits or city clerk dance permits may have been issued. I don't know if they're in the record or not, but we would have had not much to say about that from a zoning standpoint. It's a little different when you have a conditional use permit, but when you don't, you know, we have very little control over the establishment. And again, you probably haven't heard of many problems recently because the place has been closed for over 2 years.
Well, do you have any evidence of problems before that?
I don't know if anybody's kept any records of that.
The police department would have known about it, wouldn't it?
I don't know.
No?
I don't know. I don't know how far they go back. When we ask for input, I don't know how far back they go.
I'm sorry, Madam Chair. Who can answer me? Who can give an answer to this question? Whether or not the tavern that existed before this gentleman and his partner came into the picture, wanted to make it changing the inside and what have you, the genre. Who can tell me whether or not that tavern prior
prior tavern had the right or not to have shows, entertainment, or what have you?
Well, they did.
It
Oh,
says
they did.
it. Says it.
As
yeah.
I said, because we didn't have any discretionary control over them, because they had a legal non-conforming right to have alcoholic sales.
So here is the kink. I mean, if that thing, if for a technicality, that legal non-conforming right, the occupancy permit or the occupancy certificate, zoning occupancy certificate that they had not expired
2 years ago.
2 years ago, we would not be here.
Yeah, it's the same with any non. You could have had a legal non-conforming use, like a warehouse in a commercial zone, or manufacturing, or a body shop in a commercial zone. If they're vacant for more than a year, or not operating with a proper zoning use certificate, it would have been the same situation.
Okay. So for a technicality, a mistake on somebody's part, that expires. Somebody
right.
is not up. And now the CUP that comes into the picture. By the way, your comment about resembling this to a banquet hall, I take an exception to that, and I'll tell you why. You remember there used to be a time that banquet halls had the occupancy permit or the zoning certificate, and then we went out and we changed the ordinance to turn them into CUP so we can have more control over them. Am I correct?
Same thing with nightclubs, right?
Exactly. So, I mean, here we are, a use that has been there for years for a technicality, for a mistake. All of a sudden, it changes at least the way in which they have to operate it right now under CUP changes, which is to the advantage of the city. And, I don't see a problem with that. I really don't. And I will tell you why. Because if this was a tavern before, it is now. If they had entertainment then, they have now. If we want to be a business-friendly city, and we want to help these businesses establish themselves in the city, I have no problems with that whatsoever. So I guess that gives away where I'm headed with my decision.
Well, before we all make a decision, we still have other things to listen to because we haven't had the public hearing yet. But please continue with your questions of our hearing officer, Mr. Sheets, and then Mr. Lee.
Yeah, if you'd go back to the parking legal nonconforming.
Okay.
Tell me that again. Let me explain to me what.
Okay.
I heard you say that is not impacted, so it still exists.
Because it's a tavern, it was a tavern, and it's going to be a tavern again, there's no loss of legal nonconforming parking rights because of time. Use, yes.
Okay.
Standards, no.
Okay, so.
However, again, notwithstanding the whole issue about the garage, which is supposed to be a garage, notwithstanding that, or the fact that the driveway should have probably been paved in the 70s.
Right. Yeah, so
Other
that's
than
something
that.
we can deal with
Other than
condition-wise.
that.
But
Yeah.
so, really, what we're dealing with is the issue of the alcohol being served
Right.
relative to the loss of conforming.
The legal nonconforming rights.
Because somebody it wasn't carried through.
Right.
So it's not really, as far as our judgment, the parking, it's not about the parking.
Well, one of the
It's
findings,
it's
one of
legal.
the findings relates to parking.
Under CUP.
Under the CUP. Yeah.
Not before.
Yeah.
Under CUP.
Right.
Yes.
It's discretionary, so
Yes.
we had no control before.
So it's now.
Just like anything that may be a little or a lot substandard, as long as they
time
maintain.
to bring it in, that you can bring it in.
But I would just add that what.
Mr. Lee was next.
Oh, okay. Mr. Lee.
Okay. Just for, just like Mr. Storian, I'm a very business-friendly oriented person here, but I do need to clear, some of these things here. Couple of things, because one of the things the appellant has mentioned, which bothers me, and whether or not that has been discussed with our staff. And, when we have an issue with this parking, and you mentioned about the off-site parking you wanted to see some sort of arrangement, you would have preferred to see something like that. Has that been discussed? That option been discussed with the appellant? And if that's been discussed, was it the intention of the appellant to not go that route? They just wanted to stick with, no parking at all? Because normally establishments like this, I pull up to, they have a valet service and they have off-site, parking, and that type of things. So has this been in your discussion with, with the applicant? Or
I haven't really, Commissioner Lee, members of the commission, I haven't really discussed the issue because I'm not the case planner. I asked questions related to that at the public hearing. They made it clear that they were trying to, our employees might be able to park next door here or across the street. We're working with property owners, so I had to tell them, do you have anything in place now? No. Well, then, then I can't consider that. Number one, you don't have it in place. Number two, you'd need a parking use permit. So, your previous restaurant, when we were having the issues with Montrose Collection, the operators and the owner were saying, well, we own property across the street. We might be able to do, you might be able to, but you don't have anything in place and you didn't apply for a parking use permit. You've applied for a parking reduction permit. So my point in bringing that up was they seem to think they have somewhat of a need to have something other than street parking.
Obviously, but in your conversation, discussion, it was actually not formally brought up, is what I get from you.
It was brought up at the public hearing. Again, I asked them, and they said, here's what we've been doing.
Mr. Hamilton, same question to you.
Mr. Lee, I came late to this application. The case planner was Mr. Gabe Riza. He has moved on to other opportunities with the fire department. I've inherited the project. To my knowledge, those discussions have not occurred by staff, but I don't have very much knowledge about this.
Now, one of the things that the appellant has mentioned was the legal non-conforming status was, according to our staff, still valid, and they indicated that they have that on their, recording. And based on that, they moved ahead with the acquisition of the property, or the actually, the lease of the property, and then trying to establish this, business here. So, has our staff been aware of this? I mean, obviously, as a case planner and a hearing officer, that we did give, that there was that type of a transaction or that type of conversation that went on between our staff and the client.
I'm not aware of it specifically. This is the first I've heard of it, but frankly, we do make mistakes, and it's entirely possible that we told somebody in error without doing full investigation of what the history of the property was, that they had a valid authorization or continued legal nonconforming use of the site, and upon further investigation, we discovered they didn't. I mean, unfortunately, in our effort to provide quick customer service at the front counter, sometimes we speak hastily when deeper research proves that it's not, our first impression is wrong.
Mr. Hussein.
I would just say my earlier comment about the bike parking wasn't so much a business suggestion as it was to really try to alleviate at least some of the parking concerns, because if you have spaces for 10 or 15 bike parking, you can potentially encourage people to up to 10 or 15 people to not drive, take up a parking space or use another mode of transportation to get there. I would be in favor if we could even add that as a condition, possibly, because I don't think adding 2 racks in the front of the of that building, that's only up to four spaces. I think he has the potential to add up to over 10, 15 spaces, which I think would be used, considering how I've seen other places that have had that, availability. They are used. So right now, I don't think that area really has that opportunity.
Madam Chair,
Yes.
I'd like to, I don't know if this is a right time or place to ask this question, but although, it may not hinge on my decision, I do like to have a clarification from my city attorney's office on the issue of liability of our staff giving directions.
Okay.
Madam Chair, members of the Commission, I've been listening to the discussion, and the issue is really whether or not there was a detrimental reliance that was tantamount to an estoppel that may be suggested in the city's ability to further regulate or require permitting, and usually under what's called the ABCO analysis, there's detrimental reliance and expenditure of significant amount of funds, but it's on a validly issued permit. The issue also is whether or not the representation by the public official or the public representative could be relied upon due to it being valid. And so if it was outside of our ultra-virus 2, their ability to make that representation, in other words, it wasn't founded in fact, then you have to meet all of those parts of the test in order to establish an estoppel. So it's always a fact-driven analysis. I would hesitate at this moment in time to say there was or was not definitively an estoppel that had occurred, but certainly based on just the limited amount of facts without looking at documents and exploring and interviewing and doing whatever might be necessary to make it a full determination based on a full interview or examination, I would say at this moment in time that I don't feel that there was an estoppel established by this applicant. And I think that that's where you were heading.
Right. Right. Madam Chair, one more. That is, since our staff did not have full conversation regarding the parking situation with the opponent, is it possible to have that as a condition for them to consider and enter into, in order to make this more palatable for our decision?
I don't know if we could, but we could continue it. We have the option to continue it and get further information. That's an option for us, but
maybe, so is it,
Off-site parking, which is a requirement of a permit, requires a parking use permit. So it would be a new discretionary permit that we'd be asking them to enter into with its own noticing. So it's not just simple like it can be done in 2 weeks' time.
so we would, if we're going to entertain that idea, if we were to entertain that idea, would we be able to continue this with that direction, that it come back with that other parking permit to us?
Madam Chair, members of the Commission, it's certainly within your discretion to continue to consider additional factors, to continue the hearing. That Commission has certainly done that under similar circumstances. In looking at the finding that is of concern, and that is that adequate public or private facilities, such as utilities, landscaping, and parking spaces, it is also possible that the applicant can gather information that establishes that there really isn't the demand there that would exceed what is currently adequate, or that in having done that investigation, they make a determination that it would be more prudent for them to proceed through an additional parking use permit or other. We have a parking use permit. We have a parking
Reduction.
reduction, I'm sorry, I couldn't think of the other permit. So whatever options, and of course, other suggestions have been made concerning ways to mitigate the necessity of using a vehicle in order to access the site.
That is, if upon, wants to accept that terms to continue, right?
Yes, you need to move and by majority decide that you wish to continue the hearing. That would be one of the options that you could take at this time.
I might say that it would be what we consider is appropriate as opposed to what the applicant does. I think what it is, even though they may not accept it, it would be after our deliberation. If we feel that the parking is the issue and that we would like for them to address it, I think asking how they feel about it is, we already know how they feel about it. So I think that's probably not appropriate.
I think we have one more person on who wants to talk on this.
I've been waiting until we're through speaking with.
So yeah, I think it would be more appropriate if we talk about this after we hear this last person.
Well, we
speak.
asked for some interpretation, so I will be happy to conduct the meeting fully if Mr. Foy would like to talk.
Yeah, I mean, just to give the commission some more facts about how this would actually be implemented, a parking use permit is heard by a planning hearing officer. So I don't know if there's any way to just kick that up to the commission for your consideration.
There is.
So it had to go back, be another, application with its own notice, and you'd probably want to remand the CUP back to the hearing officer then.
Okay, that's
You heard at the
another
same time
option.
it's new information.
All right.
If that is the direction the commission wishes to take.
Do we have any other questions for the hearing officer? All right, we do have one public comment, and that is Ms. Elizabeth Sanchez.
I guess you can get them.
Good evening. My name's Elizabeth Sanchez, and I am a neighbor of Mike's. I live in the Americana. I just recently relocated from San Francisco. And the reason why I moved here to the Americana specifically is the mixed-use vibe. And I'm of the 80s generation, and when Mike had the concept of coming up with this wonderful live music venue, I was in all favor. And I would be a person that would walk. I wouldn't drive. I wouldn't take up parking spaces. But I think there's a great need for people of my generation to have a venue like that. So I just wanted to say that. Glendale doesn't provide that. Americana doesn't provide that. And I hope that you will approve and allow him to proceed with his wonderful concept, especially the organic concept. That's all.
Thank you very much.
Yeah.
All right. Now we will allow the appellant, you can have 5 minutes to rebut you can't talk further, you can't elaborate, but you can rebut and respond to any of the items that you have heard.
I feel that through no fault of anyone here, but switching our case planner at the last minute resulted in Mr. Hamilton not having a lot of insight on the discussion process that led up to our decisions in our application that you guys had legitimate questions about, and I think I can answer a lot of those for you. Regarding, I guess we'll dive straight into the parking first. Specifically, we applied to have the parking the way we did because that is how we were instructed by city planning. We were told that, from the beginning, in May 2011, we were informed by Howard Malis that we indeed had a grandfathered non-conforming on the space and we could open as is. And 3 days in August 2011, 3 days before we were scheduled to open and get our liquor license issued, we received a phone call stating that that was indeed a mistake.
I'm sorry, from what date to what date?
May 2011, when the previous business closed, and then the previous business closed in May 2011, and then we made an agreement with the landlord. And immediately, so after we spoke with Mr. Malis, we moved forward with securing a liquor license, and I'm starting to work on cleaning up the space in effort to run the exact same business that was there.
So 3 months
Yes.
lapsed.
And because it's a 90-day process for the liquor license. And then, like 3 days before we were set to get our liquor license issued, we were informed that we indeed did not have non-conforming because of the when the previous owner had purchased the business from the owner before that, he did not acquire the zoning use certificate. I believe he had called the ZUC. And that even though he was allowed to continue to operate for 2 years after that without one, that it was not going to allow us to operate in that space. So at that point, we started doing additional due diligence and obviously negotiating in different terms with our landlord, because we were no longer leasing a space that had a conforming non-use. And then, and part of that due diligence was going exactly through the application process. And, you know, as you guys know, that's 14 different departments of the city. We had sit-down meetings with 13 departments of the city and a phone meeting with the police, the lieutenant who's in charge of the conditional use permits with the police department. And every one of them, you know, we had discussions about what the previous businesses did right and wrong and what we plan to do. And every single one of them gave us a thumbs up. So between that decision and then we were informed by Mr. Malis that we did not indeed have the non-conforming use, he put us into, with Mr. Reza and, laid out exactly how our application would work and told us that because of the situation that we would be processed as a renewal and that we could operate the business exactly as it had been, which was our intention. We fill out the application exactly as we were instructed, which was, as Mr. Kraus noted, that it was checked as a nightclub and then changed when they, told us to mark something else. Same thing with parking is we, the business has been there for many years and the parking has always been more than adequate. We always, as we talked about everything between our drinks and our entertainment, we like to provide options for our customers, and that is why we from the beginning had looked in the parking options. As Officer Lee had mentioned, he likes to valet park. I tend to do the same. For me, I would rather pay to have somebody watch my car, but there's also people who would rather not pay to park if possible. So for us, it was just adding options. And we thought we were really lucky with it because there's a parking lot right next to us that charges to valet basically 7 nights a week whenever there was something at the business where the previous operator of the space that we were looking into. Unfortunately, and you guys noted it when we put up the map, it's Sayat Nova. And whenever we mention their name in the city, everyone kind of gets the exact same look that Chairperson Landron just got on her face. Which, if anyone isn't aware of it, they are permitted as a restaurant, yet operate as a banquet hall. So they're on kind of sketchy legal ground, which, so at that point we were informed that we could not use their parking lot, and not move forward with any kind of parking applications. And at that point in our application process, we had already moved, we're significantly into our process, and we were told by, the planning department that our application was rock solid, that all 14 departments had recommended us for approval, that they were overwhelmingly recommending us for approval, that we were the exact kind of business that Glendale wanted, and that moving the parking at Sayat Nova wasn't going to be necessary.
And this time, you're working with the case planner?
We were working, we talked to the case planner almost every day for 6 months. And then we unfortunately, he left the planning department a couple weeks ago. So Mr. Hamilton moved in and did a great job, but he wasn't terribly, he wasn't the person who worked with us hand in hand, so he wasn't familiar with all of these discussions. I believe there was a couple other people had questions about different things in our application.
I'm good.
No, I'm good. How about you?
Okay. Oh, just you brought up the bicycle parking. I actually worked in a cycling shop for 3 years before I got into the nightclub business, so I'm very bike friendly as well. And that's why I reached out to the Cycling Commission. And basically, what they told us was until they weren't going to act until we got open, or at least until we got our conditional use permit worked out. And then they would tell us how many bike racks they could put out. And from that point, we were going to explore putting ones out ourselves, but we wanted to see what the city was going to provide on the sidewalk before we explored any, on-site bike parking that would require us to open gates and things like that. But it's obviously, something that we're very into, and if the city doesn't provide adequate bicycle parking, that we're going to do it ourselves.
Any other questions for Mr. Giovinazzi?
None. Good job, thank you.
All right, thank you very
Thank you.
much. That concludes the public comment period, so I'm going to close the public comment period, although I may open it again if we have questions for staff.
Prejudice.
With prejudice.
You're closing it with prejudice.
I totally am. The question that I have here is, we've had a lot of information. So before we have, I guess, a motion, I think we should discuss some of the things we've heard. So who would like to start?
May I go first?
Yes.
I know I was this, so.
Commissioner Lee.
Right. I guess, this report has obviously both sides of, opinions or deliberation of two hearing officers on this case. And, you can make arguments for both sides. I am kind of bothered by the fact that if our city, our staff, gives certain instruction in May and in August, retracted that. But what I heard after that is bothering me more, and that is that we had case planner just continue to work with the appellant and giving directions as to, what our city department's position was. That is beyond August 2011. So, although I have concerns with the parking spaces, that, whenever the non-conformity is lost, that we need to take a look at the parking requirements and all that. From what I'm heard from appellants that they did their part. They did their due diligence in order to work with the city, to comply to the actually even to the recent codes, because after August 2011 they learned that they were under different set of rules. But again, as I continue to hear the testimony, I'm really bothered by the fact that we continue to lead these people down the wrong road. I like to see, more stringent parking requirements and valet parking, all these requirements added onto this thing here, and send it down for maybe for more provision. But after hearing rebuttal and all this, I'm tempted to go with overturning and just allowing them approving the CUP at this point.
That's what your planning staff is recommending, by the way.
Yes. Yes.
That's right.
Yeah.
That's what your planning
That's what I
staff
said.
is recommending.
Yes.
Mr. Sheets?
Sure.
My normal tendency would be to immediately say no, because I thoroughly agree with the parking concerns in our community. And I'm not sure that this business model will work. It's odd how we've gone from doing a CUP, reviewing for a CUP for alcohol serving, and we've taken a convoluted route to get to working on the parking issue. So, but it's been explained. I see how it happened. So for me, it's not about giving permission to serve alcohol. My concern, whether it's an issue or not, is the parking. And I fear that your business model, if successful, will exacerbate that issue, which is good for you if it goes through. And what happens beyond that, I guess, would be up to your ability to manage the situation. But I would say that I think the appellant's done a good job. I think you're very positive, very upbeat. I think you tried to do due diligence, but in the real world, it wasn't thorough, it wasn't complete. However we get there, it wasn't accurate. Not that it's your fault. I too am concerned about the change of the case planner. What can you do about a situation like that? And the issue around the confusion around legal usage and non-legal usage, and your understanding of that. And I'll also say I'm concerned about your business model with concerts. Concerts conjure up all kinds of things. So I'm mixed. I'm torn. But I'm leaning towards giving the benefit of the doubt towards your intentions and what you presented to us today as far as the business model and what it can provide for the community. So that's all I have to say now.
Mr. Singh?
Well, I always find it interesting when there's disagreement within staff. I think we all do, because it makes for a more interesting, engaging dialogue that we get here.
Certainly a longer one.
And also a more learning process for us as well. I do also find it interesting that sometimes when there's like a big name or like a big chain like Starbucks coming into, like for example, Montrose area, we tend to make things so easy for them and try to, waive any parking requirements or anything, do what we can to find off-street parking, to make the justification that they're okay to come in. Because they may have the lawyers or whatever, so they can make, get the department to see that this may be, it's a legal thing to do. But when we have small businesses like this, it always seems like such a struggle to do this. We don't have those, Starbucks and those franchises coming before the Planning Commission, because they usually get dealt with the planning hearing officer, and the department, I think, takes a stand and makes a decision early enough so it doesn't have to come here. But when it comes to people like smaller businesses, we don't see that. And it's usually a much more difficult process for them. And I think that's probably why we hear a lot of complaints in the city. And I know the city's doing a lot to improve it, and I think the process has been improving in the last couple of years. And I would be in favor of this. I think it's interesting that it doesn't actually have parking, even though this type of use has happened before without any parking. I also find it interesting that, when we do approve this, or if we do approve it, which I would approve it, to see how it actually works out, without the parking. I think that might actually encourage people to use other ways to get there, because it's not going to make it so easy to just go and park there, which is why I mentioned the stuff about bike parking earlier, but it's also close to a lot of people, the Americana, and a lot of people who live near there, so they can actually walk there as well or take the bus. So it might actually encourage that. And I am interested to see what happens. And I would be in favor of this, and I would actually make the motion for it too after Mr. Astorian gets to speak.
And I do too.
Yeah, and you too.
Commissioner Yesayan, that was quite an observation. Thank you. I could not have thought of it as eloquently, I would articulate it as eloquently as you just did. Having said that, the issue here, in my opinion at least, is not whether this is a small business or a large business. The issue here is we've had a business, the same type of business, in the same location for a number of years, decades. For a technicality, the ZOG is gone and the CUP is in. That works to the advantage of the city. For whatever reason, if they have issues, this is why the CUP would play a great role. Let's revisit this establishment in 2, 3, 4 years. And if they're not doing what they're saying or they're not up to where they are, that's why you're doing a CUP as opposed to a certificate of use or zoning use certificate. So that's the kink. Nothing has changed. The business model, maybe, the genre maybe will change. But to me, nothing has changed. Then, May, and this, I'm glad that the speaker did speak, May of 2011, we are 14 months in, and we could have had our bike racks in there, we could have had our shows in there, we could have, I mean, it's a bit excessive and burdensome in my opinion. I do agree with the condition of the bike racks. I also do agree about paving the driveway. And I do also agree with Mr. Hamilton about the classification of the garage or the pseudo garage storage. All of those things I agree. I have no problems with, and I can work with you on those. Thank you.
Well, I am going to apologize to you for the fact that you had some differences of opinion that have affected you. Part of that is Governor Brown and the CRA removing a lot of our planners and leaving you with Mr. Hamilton, who did probably a great job of taking over the project when we lost other planners. We don't really have we provide you with the service that we can. The other issues I would like to talk about is I think I'm going to ask if we can do something, and I don't know if we can, but I would like to add to the conditions of approval the requirement for security, that there would be a guaranteed security officer on the site during these events. I think that's going to protect you and certainly the neighborhood. I would also like to ask our council, so I'll have to open the public meeting here, if we can require that valet parking be required. And that would solve my feeling about the parking issue, that for events that are on the weekend, that valet parking be required. That would mean that you would have to figure out how to do that, but to me, that would address the parking issue. It's not a discussion, sorry, but we would like to do that, but we can't. So
Yes, Madam Chair, members of the Commission, it is a separate permit, discretionary permit through the Traffic and Transportation Division, so that you can condition them to seek that approval for valet parking to the extent that, based on the analysis required to have that permit issued, they're able to satisfy that and to obtain it as a consequence. So.
All right, thank you. What that would do is it would satisfy the fact that really parking is the issue. With the neighbors, you want the neighbors to like you. We want the neighbors to like you. I want you to have, the dregs of society, but I've never seen them live, and I'd like to. So one of the things I think that we really need to do is to see if we can put these two conditions on there. They really are a band.
Dregs of Society?
Yeah, they have a great album called Industry Standard. I'll lend it to you. It's really an album. Do you have a record player?
Madam Chair, they did mention their hours of operation, so that should be part of the...
Yes, we would like, and I guess I'd like to ask council and planning staff. For this type of establishment, are the hours that were mentioned, which are Monday through Thursday, 5 till 2, and Saturday and Sunday being 12 to 2, are those typical for that type of establishment? Is that something we do in the city? Mr. Foy?
Yes, as far as I'm aware, that it's quite common that taverns stay open until 2 a.m.
Okay. So,
Correction, it's actually Sunday through Thursday, and then Friday and Saturday is 12 to 2.
is that the correction? No, he didn't say that.
Well, it's 5 to 2.
It's 12 to 2 on Saturday and Sunday. And
really?
Monday through Thursday, it's 5 to 2. Friday. Oh, right. Monday to Friday. I got that right. All right. So
Is that a separate condition?
I
Or
think
it's
that
just-
we would want to have the hours of operation within the conditions. Is that all right?
Yes. Yeah.
Thank
Can you
you.
please repeat the hours of operation, Monday through?
Friday, 5 to 2. Saturday and Sunday, 12 to 2.
Thank you.
And I'm going to ask Ms. Van Buren, how would we phrase the valet condition to meet?
May I ask you a question?
Sure. Please do, Commissioner
Now,
Story.
From what the city attorney was suggesting is that we can make it a condition for them to seek.
Right.
Now, seeking and being granted are two different stories. What's going to happen if, I don't know who the authority is going to be reviewing this thing and say, okay, yes, we will issue you a valet parking permit, or you know what? No, we're not going to issue a valet parking.
I've thought about that.
And where
Here's
is-
my thought, is that I agree with you. I understand that it's outside of our ability to make that, is to allow them to operate for the first year while they are seeking that, but that it should be in place by the end of the first year.
So what if they say no?
And what if they say no at the end of the first year?
They're not going to say no.
This is just like that previous case that we had, the easement. We have an easement, but it's indefinite. I mean, we don't know whether or not it's going to be. So I just, you know what I'm trying to, and I
You know what?
appreciate-
I understand what you're saying, and I understand the concern here, but our purpose is to interpret the code so that it benefits the whole of the city. And to me, if we don't deal with the parking, we are doing a disservice to the remainder of the city outside of this one lot. To me, I find that that's an obligation I think we have to address.
My concern with the valet parking is that, I guess my concern would be that the valet service would just park in the surrounding streets, because there isn't really a lot.
Hopefully that's
there.
what the process with the traffic commission is, that they have criteria. And that would be that's my perception, my understanding. They'll go through another process, and they have to fill it out, and they'll be told what they can and can't do.
And where they
That's
can
what I
and cannot.
picture that process being. If I'm
And
wrong,
that's
then
why it's better than, there's no way we can add parking to this. I think we want it to go forward.
Madam Chair, if we do, how about if we do this? We make a condition to seek the permit for the valet parking. Now, in the process, we're giving two years CUP out,
Right.
anyways. In the process, not of their fault, but whatever the reasons, that if the decision from there comes unfavorable, that they do not give the permit, that would not, be the trigger point to nullify the CUP, but, just for us to put a condition in there for them to go ahead and seek that, so that they have to show proof that they have, that they are going through the process. But our decision should not be hinged upon on the approval or disapproval of that of the valet service. That, I think, will solve your problems.
I don't have a problem with what is suggested. What I do have a problem with is uncertain outcomes.
Yeah, but that will not have any hinging on this decision.
let me make it more confusing.
All right, make it more confusing.
I think what we've done here now is we're circling back, and we're talking, it's not about valet parking, it's about parking.
Right.
And parking can be any number of things. So, although I agree with Chairperson Landrigan, because one of my comments, and it was already taken, was about the valet parking. I have mixed emotions about that because there are conditions, there are reasons that we shouldn't do it. But to me, if we're going to talk about valet parking, we need to talk about parking. And we're opening up a whole new process that we really need to clearly define where we can park, what's available, what's the impact on the street in front, what's the impact on the side streets. And my conclusion and my decision is based on the fact that we got here and we worked through the process with them trying to do the right thing. I'm going to give them the benefit of the doubt that this will work. But the valet parking, as far as pursuing it, I have no objection to that. But if we start to add pieces to it, then I have a problem.
So I'm hearing that if I suggest valet parking be sought without any other restraints on it, that it is a popular addition to this condition. However, I add others, this would not be supported by my fellow commissioners.
Well, I think if it was denied, then
We
I
don't
think
want it to kill the whole thing.
Yeah, they
Right.
satisfy the seeking.
Correct.
That shows a good
I'm
faith effort on
happy to
everybody's part.
have that phrased to popular opinion.
Okay.
I agree.
Okay, thank you.
So we need a
So
motion.
may I have a motion?
All right, I'll move. I move that upon review and consideration of all materials and exhibits of current record relative to conditional use permit case number PCUP-12-06549, located at 806 East Colorado Street, and after having conducted an appeal hearing on said matter, that the Planning Commission hereby overturns the planning hearing officer's decision and approve said conditional use permit case number PCUP-12-06549 to allow the sale, service, and on-site consumption of alcoholic beverages at an existing tavern located at 806 East Colorado Street in the C3I-Commercial Services Zone, Height District I, described as portion of Lot 23, tract number 1164 in the City of Glendale, County of Los Angeles, in accord with the findings and conditions listed below, with the additions of finding condition number 22 to add security during operating hours of the tavern.
At the time of when they have
Event.
Oh, I'm sorry. To add security during time of events. Number 23, to add the condition that the applicant will seek a valet parking permit.
I have some language if it's the wishes of the commission for me to share.
That would be great.
The applicant shall seek a valet permit before the end of the first year of operations and provide evidence of such application to the Director of Community Development.
That's great. So 23 is what staff just described. Number 24 would be for operating hours to be limited from Monday to Friday from 5 to 2 a.m. and Saturday and Sunday to hours to be limited to 12 to 2 a.m.
And what about the bicycle parking?
Oh, yeah. Are we doing that?
Yes.
I think so.
Oh, yes.
Okay, and number 25, that bicycle parking to be seeked from the city, and if adequate parking is not available, then for adequate parking to be available on site.
And how about paving the driveway and turning the garage to it?
Number 26, for paving of the driveway to commence by the applicant. And number 26, for the garage to be returned to its original use.
Mr. Foy has a...
Mr. Foy?
Could I just ask for a little clarification on the term events? I kind of got the sense from the Commission's discussion that you were referring to when there was a live band playing?
Yes.
Yes.
Okay. So other things like spoken word or karaoke night
Bingo,
wouldn't
those things
necessarily
are-
need it? Okay. Just when there was a live...
You've already taken on under condition number 18 an event that would have
Right.
Yeah.
So.
would have been considered an event.
So we have a motion with some additions to the conditions. Do we have a second?
Second.
May I have roll call, please?
Commissioner Sheets. Aye. Commissioner Lee.
Aye.
Commissioner Yasayan.
Aye.
Commissioner Astorian.
Yes.
Chairperson Landrigan.
Yes. Now I have to read this thing, if I can find it. This is an appeal, so any individual not satisfied with the Commission's decision may file an appeal to the City Council. This is done by filing a notice of appeal along with a filing fee at the Building and Safety Division located at 633 East Broadway, Room 101 in Glendale, California. Any appeal must be filed within 15 days. That concludes this case. We will move on to our next agenda item, which is Planning Commission items. Do we have any items from the department?
Well, the only item that we had is that there was an appeal of the Rimcrest decision, and that item hasn't been scheduled yet
Can you take his question?
for a council hearing.
Okay. Could you repeat that, please?
That there was an item on Rimcrest that you heard it was appealed, and it has not been scheduled yet for city council.
Uh-huh.
And I would also add that last night the City Council adopted the ordinance you recommended establishing Ross Mine as a historic district. Also adopted the amendments to the Downtown Pacific Plan that the Commission had recommended. And in addition, they initiated a series of miscellaneous zoning code amendments, which you will be hearing in the future.
Was there, I thought I remember reading somewhere that there's something the city council didn't agree on. Was that true? That we had either passed or didn't pass within one of those things? I thought I read that somewhere recently.
Yeah, I think what they disagreed with the Commission on was allowing billiards without a conditional use permit in the downtown.
Yeah, that's what it was.
disagreed with
Now, when did we?
Allowing billiards.
We did that in the in the new
got it.
designation of
Yeah,
land use.
What was the exact issue that they disagreed on? Because I remember it was very pointed that why did the Planning Commission do this?
Right.
I remember reading it, even though I wasn't there. So I don't know what you guys did.
You didn't.
So we're
They
not
had
gonna tell you then.
recommended that billiards be a by right element and did not require a conditional use permit or any other discretionary permit. We felt that billiards created community concern, and so it needed to have a public process.
Oh, got
They
it.
disagreed with us.
Okay, got it.
That was our recommendation, and they decided in their authority to do it,
And wisdom.
wisdom, other things.
Got it.
Thank you.
Now, is that the end of our agenda? We have no more items that I know of, unless commissioners would like to make comments.
I have an announcement.
Please, Commissioner Lee.
5 years ago, H.R. 121 was unanimously passed in the U.S. Congress. It's a House Resolution 121. And what it is that, in our history, we had, in different countries, different cultures, that we had some really devastating experience with genocides, Holocaust, and so on. And there were dark times in our history, Korean history, with the military occupation of Japan over Korea, that the comfort women were taken to various military locations for as what it says, as a comfort woman, to comfort their soldiers. there are survivors from this ordeal, and actually there's artwork that depicts, what happened in the dark history in our Korean history. And this artwork, the pictures are displayed in Grand Central Library
Glendale.
from July 23rd to August 3rd. And on July 30th, which is Monday, at 6:30 p.m., in the auditorium of library auditorium, that we have a ceremony, remembering these people. And there is actually surviving comfort women that will be there, during this ceremony. So I invite everybody to come to the library auditorium Monday, July 30th, 6:30 p.m., but also come during the week of exhibit, which is July 23rd to August 3rd, to look at the art exhibits. Yeah.
And this is the Glendale Library?
Yeah, Glendale Library. Yes.
Thank you, Commissioner Lee.
Thank you.
I hope that all of us are able to see this
It's great.
exhibit. Are there any other announcements from commissioners? May I have a motion to adjourn? We are adjourned.